Yes, Mr. Mohanta.
So, my lord, I have no mention, but address head, my lord.
Yes.
I beg to mention item number 44 of the supplementary list, my lord. I am mentioning on behalf of the respondents, in this matter, 44 of the supplementary list.
Yes.
In this matter, Ms. G. Goswami has been briefed,
So, my lord, I have some urgency. It's a motion, my lord. Can it be tomorrow, my lord, in the other bench? It's a motion, my lord. We have very urgency.
List before any other bench, item 44. Rupak, Kalir Karne koi dibo.
For tomorrow, my lord.
Deep level.
Koi dibo, file to put here.
May I read your lordship?
Yes.
Item number 28, I have to file an affidavit, my lord. Item number 28.
28.
28. My list after application, my lord.
You are for?
Petitioner.
You have filed an affidavit.
I will have to file an affidavit.
You want to file a rejoinder?
Yes, my lord.
As prayed for by Mr. G. Pathak,
Jiba.
Learned Counsel for the petitioner lists this matter after 3 weeks to enable the petitioner to file the necessary rejoinder in the matter.
May it please your lordship. Lordship, with the consent of the Learned Counsel of the petitioner, I beg to mention item number 38. Lordship, I am appearing on behalf of Mr. S. Mitra.
38 is an order matter.
Order, madam. My lord, because of the IA, it has been listed for order.
Please wait for the turn.
Lordship.
No mention of any orders, please.
Lordship.
I shall accommodate when the matter reaches.
Lordship.
Yes.
May please.
So for item number 8, the petitioner doesn't want to pursue the matter.
Item number 8. Heard Mr. M.K. Sharma, Learned Counsel for the petitioner. Stop. Also heard. Yes, anybody for oil? Standing Counsel oil. Mr. Sharma is there, no, for oil? Yes. Can you? Are you there for?
Mr. E. Sharma, Mr. K. Kalita.
Mr. K. Kalita.
Yes.
Mr. And also heard MS K. Kalita or
Mr.
Miss?
Mr.
Mr. K. Kalita, Learned Standing Counsel, OIL. Stop. Mr. M.K. Sharma, Learned Counsel for the petitioner, submits that he has received instructions not to from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the writ petition. Stop. Prayer allowed. Matter dismissed for withdrawal. Writ petition dismissed for withdrawal. Disposed of.
May it please your lordship, my lord, with the consent of the other side, my lord, I beg to mention item number 17, my lord.
Yes.
My lord, here I need to obtain some instructions from the petitioner. May it be taken after vacation, my lord.
You are Mr. Mishra.
My lord.
As prayed for by Mr. R.S. Mishra with consent from Learned Counsel for the petitioner with consent from the other side, list this matter after 3 weeks on a date to be fixed by the registry.
Deeply obliged, my lord.
Lordship, I beg to mention for listing of a WPC Lordship for tomorrow Lordship.
Asset to Itya bench. Senior bench is available. Mentioned before the appropriate bench. Bench 5?
Yes, sir.
Yesterday the bench was not available. That is why mentions were allowed in this. Yes.
Lordship, with respect to item number 7, your Lordship, herein we have not been able to contact the petitioners. So we need to take instruction if anything survives, your Lordship.
You are Mr. S. Bhattakur.
Yes, I'm S. Day, my lord, on behalf of Mr. S.
As prayed for by Mr. S. Day, on behalf of Mr. S. Bhattakur, Learned Counsel for the petitioner, list this matter after, which is not opposed by the other side, list this matter after, give a date after 3 weeks, on such and such date to enable the petitioner to obtain instruction from the petitioner as whether anything is still surviving for adjudication in the instant proceedings. Stop.
Much obliged.
Yes, Mr. Bhattakur.
Yes, such case, my lord. In fact, my lord, the petitioner, my lord, happens to be the father-in-law of the informant, my lord. The matter has been settled between the informant as well as the petitioner, my lord.
Which document?
My lord, kindly see page 23, my lord. She has also thrown an affidavit also, my lord. Here, my lord, she has given this petition, my lord, before the learned court below, my lord.
This is a joint
no, my lord. In fact, my lord, the informant happens to be the daughter-in-law of the petitioner, my lord.
He wrote an allegation, my lord, against her father-in-law as well as mother-in-law. Otherwise, my lord, he will appear, my lord.
Otherwise,
Next date is, my lord,
cases of
2017.
2017.
No, but in
For
view
appearance.
of this,
Yes, I'll leave it to him.
so I'll give interim or I'll make it absolute.
Let him appear before the.
Yes, sir.
And let him appear before the.
So interim.
Your Lordship, we can dispose of.
All right, yes. Heard
Yes,
Mr.
S. Islam.
S. Islam, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. This is an application under section 438 of the CRPC for granting the privilege of pre-arrest bail to the petitioner, who is petitioner Taizuddin, who is apprehending arrest in connection with PRC case number 720 of 2023 arising out of Kalgatia PS case number 849 of 2017. Stop. Where is the FIR?
FIR is at page, my lord, 12, my lord. Translated.
The case of the prosecution is that on 28/12/2017, the informant lodged an FIR alleging inter alia that the accused stroke petitioner, who is the father-in-law of the informant, along with co-accused grabbed her from behind and made her sit on a chair against her will and raped her by gauging her mouth. Stop. Accordingly, the FIR was registered. Stop. Mr. S. Islam, learned counsel for the petitioner, submits that the FIR was lodged due to misunderstanding, and the informant, where is our affidavit?
At page 25.
20,
And the
25, 23.
informant, upon realizing the same, comma, deposed before the notary public Borpeta to the effect that she will file an application before the Districts and Session Judge Borpeta for withdrawal.
She cannot now withdraw the case.
In this regard, stop. The said affidavit, stop. Mr. Next paragraph. Mr. P. Borthakur, learned APP, fairly submits that submits that if the petitioner cooperates with the investigation and appears before the investigation officer, comma, there is comma, he does not object to the grant of anticipatory bail, subject, of course, that conditions are necessary conditions are imposed.
Now, he is informed. In this case, already search sheet submitted.
He will appear before the
He is shown as absconder.
committal court, my lord.
Cooperate with the trial.
Yes.
Heard the parties at length and perused the materials available on record. Stop. It appears that the
Page 6, paragraph 10.
page
Page 6, paragraph 10.
It appears that the charge sheet has already been submitted. It appears that the investigation is already completed and charge sheet has also been submitted before the trial court.
And my lord, summons also issued, my
And
lord.
summons for appearance.
Yes, summons for appearance.
Appearance has also been issued
Yes.
The petition.
by the trial court.
Yes.
Stop. It further appears that there are documents annexed to the anticipatory bail application to suggest that the informant, due to misunderstanding, had lodged the instant FIR. Stop. In view of the aforesaid, this court is of the considered opinion that custodial interrogation of the petitioner may not be justified at this stage. Stop. As such, the anticipatory prayer for anticipatory bail stands allowed. Next para. It is accordingly provided that that the petitioner named above, in the event of arrest in connection with the aforementioned case, shall be released on bail on furnishing of bail bond of rupees 25,000 to the satisfaction of
My lord,
CJM Borpeta.
because CJM
to
court,
the satisfaction of
Committal
CJM
committal court.
Borpeta,
Yes.
subject of course to the following conditions. Number one, that
He shall appear before the trial court. on
he
the
shall
case of-
appear before the trial court on every date, on each date fixed. Correct? And then the next 2-3 conditions and disposed of.
Highly obliged.
May I please your lordship?
Yes, Mr. Jarika.
Lordship, here I'm aggrieved by the fact that I'm aggrieved by the fact bids were called by the ONGC and there were certain experience clause. We having qualified, me and 2 others were selected for the financial bid, price bid. One, the respondent number 5 was technical bid was rejected. Now what happened? The respondent number 5 filed a representation before the Independent External Monitors, which is a committee constituted under the Central Civil Vigilance Commission, basically to look into the integrity
Grievances.
and things like that. And they said that this experience clause, they had a grievance against the experience clause, and he enlarged the scope of the committee enlarged the scope of the experience clause, and told ONGC to reconsider, that they may reconsider. Of course, it has said the opinion of the external monetary external committee is not really binding on ONGC, but
They made a suggestion.
it's a suggestion, but it is seen from experience that ONGC normally accepts that. Now my grievance is that you had already rejected him on 2 or 3 grounds. Thereafter, now if you take him back for the financial, we will be pitted against a inexperienced person, a person who actually does not qualify as per the bid document. And
But till now, nothing has been done by ONGC. They have not accepted. You are apprehending that they may
I have
accept.
common apprehension. So I want a little protection that the financial price bid may not be opened of the 5th respondent without leave of this court. And let ONGC
There is no
respond.
standing counsel for Oil and Natural Gas Corporation. Mr. Borwa, any standing counsel is there for Oil and Natural Gas Corporation?
They have a sort of panel council.
So generally, yes, Mr. Chaudhary?
I am on the panel, Melo. They do not have a standing council as such. Notice has to go, Melo, then they'll allot the matters.
No, but you are in the panel.
I am in the panel.
So notice has to go.
Yes, Melo.
Because we did not. Let a notice go.
Yes, yes.
And in the interim, nothing will
Ms. Chaudhary, where is that order of that internal committee?
Lordship, I think that's an email.
Where is that?
There are 2 emails actually. I've given the typed copy. The first one is at page 39.
First, you show me do you have the copy of the rejection order that they are not technically qualified because their name may not have appeared when the price beads were.
No, Lordship, we do not have the rejection order, but they have filed a representation to the
where is
they
that?
have respond number 5
Where
has
is that?
said. Annexure 5, page 35, Lordship. Submission of this surprisingly we have been received a mail on this from ONGC stating that our response our bid responded number
All
this
right.
has been rejected.
All right, now next.
Next, Lordship will come to page 39. That's a typed copy.
This is that committee.
That is the committee, the External Monitors Committee. Lordship, the relevant portion.
They are called the Independent External Monitors.
Yes, sir. Independent External Monitors. And that is under the vigilance. Lordship, at page 40 is the relevant. We have noted that ONGC had not considered work orders placed by IIT Guwahati. However, as per the BEC, fabrication experience in any large industries is acceptable. Phrase any other large industries stipulated in BIC is very generic one, which covers education sectors like oblique industries. If ONGC intended to restrict the qualifying experience to specific industries, then the BE should have been.
But Ms. Hajorika, you see now, this is what they are not saying that you are bound by it. They are making it very clear, isn't it?
Yes.
The IEM opinion is non-binding in nature, and above part of the opinion is being shared in the interest of transparency. Right. Now, it is upon the author of the bidding document ultimately to make a call. Now, suppose it is in their opinion and wisdom that the IEM is correct, then how will this court go into it? Unless, of course, you allege malafide or...
Yes, Lordship,
isn't it?
I allege that by this interpretation, you have enlarged the scope of experience.
True, but then...
And that apart, there are 3 other clauses on which BEC is rejected. Now,
when is the financial bid opening?
Any day now, Lordship. That's vacations are coming. That's my apprehension. And Lordship, there's another...
what is this tender for?
Tender for is a specialized tender, Lordship, in the oil fields, so drilling, etc., those pipes, fabrication, oil tanks, etc. It's a very specialized tender. And Lordship, this is not the only rejection.
Is there any document on record showing the nature of the powers that this IEM has? What are... anything in case is available?
I have quoted some. It's advisory. And
where is that? That it is only advisory?
Paragraph 4 and 5. The function of the external, independent...
Yes, I've got it. Paragraph 5, right?
Yes.
So according to you, their function is that they will examine the grievance. If there is some lapses on the part of the tendering authorities, then they may point that out. But here they have interpreted the experience clause, which is beyond their competence. This is what you are trying to say, right?
And Lordship looks at page 8. It's very clearly stated that out of the many roles, the main role of independent external monitors is advisory, and the advice of the independent external monitors is not binding on the organization. It is advisory only and helps proper implementation of the Integrity Pact. Basically of the Integrity Pact. So I want this small protection so that we do not... And then, Lordship, there will be a lot of other people who will be deprived of this tender. And the competition won't be fair.
Heard MSM Hajorika, Learned Senior Counsel, assisted by MSS Newer, Learned Counsel for the petitioners. Petitioner, stop. By filing this petition under Article 226 of the Constitution of India. The petitioner is apprehending that the respondent authorities may reconsider the techno-commercial bid of respondent number 5 and open the price bid of the respondent number 5 in view of the
opinion
given by the
independent
internal monitors within bracket IEM by their communication dated 04/06/2024. Correct?
Yes, and one more.
Bracket Annexure 6
and Annexure 8 also.
Where is that?
At page 45. This was forwarded to us.
And email. Is this an email?
Email, right.
An email dated 25/6/2024.
Yes.
Stop. It appears that the writ petitioner has filed this instant writ petition against the threatened action of respondent authorities to reconsider the techno-commercial bid of respondent number 5, who is not technically qualified as per the technical bid evaluation criteria and whose technical bid has already been rejected by the ONGC Vide. Okay, that is Vide, their email dated 29/4/2024 issued to the said respondent number 5. Stop. It further appears that the respondent number 5 represented before the independent external monitors, who thereafter
opines advise ONGC to review.
Opined. Where is that part?
Lordship, at page 40.
Opined that ONGC, that part, right?
Yes, Lordship.
We noted that ONGC.
Yes.
Opined that ONGC has not considered work orders placed by the IIT Guwahati and as such advised the ONGC authorities to review evaluation of the offer given by the respondent number 5. 5 or 4? 5. Stop. MS M. Hajorika, Learned Senior Counsel, submits that the function of the independent external monitors is to examine all the representations, grievance, complaints received by them, and by no stretch of imagination they can interpret the tender conditions and or enlarge the scope of the tender conditions. Stop. Issue notice. Next para. Issue notice returnable 4 weeks. Steps by registered post AD within a period of 2 days from today. Stop. Paragraph, in order, then you say, paragraph 4 and paragraph 5 of the writ petition is reproduced hereunder for ready reference. Stop. perusal of the aforesaid averments on oath indicates that the function and role of the independent external monitors is only advisory and is non-binding on the organization. Stop. It further appears from the communication dated 04/06/2024, which is enclosed as Annexure 6 to the writ petition, that the independent external monitors, while examining the grievances of the respondent number 5 as regards the rejection of their bid by the ONGC authority, interpreted the experience clause and is advising the ONGC authorities to review the rejection. Stop. The aforesaid therefore, prima facie, it appears that the IEMs have acted beyond their jurisdiction, and hence the opinion given by the IEM appears to be prima facie illegal. Stop. As such, pending adjudication of the writ petition, it is provided that the price bid of the techno-commercial bid of the respondent number 5 shall not be opened,
not be reconsidered,
shall not be reconsidered by the tendering authorities without the leave of this court.
Obliged.
Stop. List after 4 weeks and a date to be fixed by the registry.
May I please, Your Lordship? Lordship, petitioners are NF Railway OBC Employees Association, Lordship. They are in existence since 1999. They have received the recognition of the General Manager NF Railway, and they are in existence. Now, Lordship, every 2 years they conduct election, and they are continuing. Last list of elected office bearers is dated 14/8/2023, which is at page 54. Now, in terms of Railway Board's letter dated 3/10/2017 and 11/11/21, I have enclosed those letters. It is incumbent on the railways to circulate our list of elected office bearers.
Circulate?
Our list of elected office bearers, so that we get some facilities, recognized facilities. Many facilities, Lordship, room, office, table, chair, internet
Mr.
connection.
Gupta shall issue notice at this stage.
Lordship, some interim protection, Lordship, because now
what interim first?
They have issued one impugn order against this letter. We submitted representation for circulation of our list of elected office bearers. They have rejected it by issuing impugn letter at page 83. They say that within 15 days, they are under impression that, Lordship,
yes.
They are under impression that there are two rival groups within the NF Railway OBC Association. There are two rival groups, two parallel rival groups within the NF Railway OBC Association. Now, that fact has been clarified by our All India body also in the previous page 82. Impugn order page 83, they have told that we are giving you 15 days time, you submit a list, a mutually agreed...
You are challenging the
page
83 order.
83 order. 17/6/24 order. Last paragraph.
Yes.
They say the available facts and materials on record do not appear to support the claim of any of the groups of NF Railway OBC Association, Employees Association. Accordingly, both the groups are advised to hold mutual discussion.
Yes, what is wrong about this?
Yes, on 3 grounds I am challenging, Lordship.
I am issuing notice right now.
No,
sorry. I'm also issuing notice on your interim. If you want, I can decide the interim. You want notice on your interim, or you want?
Notice will do, Lordship.
Yes.
One small submission, Lordship.
Sorry.
15 days time they are giving, Lordship.
Heard, Mr.
GJ Sharma, Lordship.
Your name is not there. Item 43.
43.
DJ
Sharma.
Heard, Dr. GJ Sharma, Learned Counsel for the petitioner. Stop. Also heard, Mr. Yes, Gupta. H. Gupta, Learned Standing Counsel, CGC. Only CGC. Learned CGC. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is challenging inter alia the letter dated 17/6/2024, Annexure 19, and seeking direction from the respondent authorities to circulate the list of elected office bearers of the Petitioner Association communicated by letter dated 14/8/2023 to the GM, NF Railway. Correct?
Yes.
Stop. Issue notice, returnable 4 weeks. Mr. H. Gupta, Learned CGC, accepts notice on behalf of respondent number
1, 2 and 3, my lord.
1, 2 and 3. Extra copies within the course of the day. Steps by registered post in respect of respondent number 4 and 5. Steps by registered post within a period of 2 days from today. Stop. Issue notice on the interim. Prayer. Stop. List. Give a date after opening.
After opening, Lordship. First week of August.
17 July.
The returnable date by then
My lord.
will get over. On such and such date. 17 July.
Lordship, till then, can you be status quo, Lordship?
Nothing. Yes.
Obliged.
Yes, are you going to take steps, or I'll dismiss the writ petition?
We'll take fresh steps.
You will take? How much time?
Petition. We'll take fresh steps by tomorrow, Your Honor.
Your name?
D. Borua.
MSD Borwa, Learned Counsel for the petitioner, assures this court that fresh steps shall be taken within a period of 2 days from today. Stop. In view of the aforesaid assurance, list this matter after 3 weeks on a date to be fixed by the registry.
I am appearing in item number 4 as a respondent number 2.
That's all right. 2, 3, 4, 5, 6, right? Electrocution.
My lord.
Yes, Ms. Das.
Report is here, my lord. Report, Lordship will find and page 4 of our application. Here, my lord, it says, my lord, probably, my lord, cause is leading to the accident, my lord.
There is negligence
Negligence
attributed to the petitioner as well as the APDC. I have to be fair, my lord.
Fence was not there and he climbed the transformer.
Now, my lord,
Where is this affidavit?
27 affidavit opposition, my lord.
Affidavit by one Mr. Utpal Kaur.
Yes, my lord.
And
Yes,
the report is
Internal page 3, my
3.
lord.
3 it starts.
Where do we get this? You see, contravention they are showing regulation 12.1, regulation 49.1.2, then regulation, then they are saying contravention on the part of the victim.
yes, my lord.
Yes.
But your contraventions are there.
Yes.
Yes, my lord. So, there is an appeal provision. We instructed the department to file an appeal against this report itself. That instruction is awaited, but the outcome of the appeal or whether or not that appeal has been filed at all. So, my lord, I am only praying for.
Now, what does that appeal provision say, Mr. Chaudhary?
My lord, if any of the parties are agreed by the report of the Chief Electrical Inspector, an appeal is provided, my lords, to the appropriate government. Now that whether or not the APDCL has availed that remedy, my lords,
So I'll post it after the
immediately on
vacation.
reopening, my lords, I'll get that
In the meantime, you obtain
Yes,
it.
ma'am.
Otherwise, you see,
Otherwise, my lords, it has
this
to be allowed.
court feels that since there is
Yes,
contravention on your part,
Yes,
you merely cannot.
yes, my lords.
This court cannot ignore it
Yes,
just because there is some contravention on the part of the victim. You are an authority. It is your duty to ensure that you see that you
there
can't.
was supposed to be a fence around the transformer. Yes, my lords.
Anyway, Mr.
B. Chaudhary, my lords.
B, no?
B.
Mr. B. Chaudhary, Learned Standing Council, APDCL, submits that he seeks for 2 weeks' time to obtain instruction as whether any appeal has been filed against the report of the Deputy Chief Electrical Inspector in the matter. Yes. Stop. List after prayer allowed. List after did talk after depression.
I'm deeply obliged.
Compensation not given.
Compensation will not. Land
Jirat.
acquisition compensation was given, but compensation for fishery is not given. There is 8,500.
Affidavit only by 1, 6 and 7.
Yes.
1, 6 and
For
7
the
is-
railways have filed it.
You have filed?
Yes, yes. I
Huh.
filed.
Railway
My
has filed.
submission is that, my lord, probably you also agree, my lord. We have already paid the compensation. He has received it. Now, his claim is that he is supposed to receive rupees 8,000 something as Jirat compensation for the fishery. Now, if that is decided against us, we will pay that also. But this honorable court, my lord, in our
How will this court go into all that?
That is, Milord, I also agree.
Then-
and regarding this amount, quantum of
The
compensation, quantum section 18 of the Erstwhile Act, there is the.
Otherwise, you
provision
have
for
got it. If you are not satisfied, the remedies are available
Yes,
in law.
Lord. So what
Have you
my-
availed them?
That, Milord, the
You want to
representation
withdraw
was,
this, or I will dismiss it?
representation was filed before the Deputy Commissioner, who is the authority to refer. So, Milord, my humble submission, the Deputy Commissioner may refer that my communication was
Please
there.
do not convert the Article 226 Constitutional Court into an executing court.
No, I agree with that.
You
I
have
cannot praise
remedies
that.
available. Please avail them.
My lord, I will go for that. Only, my lord, this fishery 8,500 for Jirat, that I have filed representation, and that may be considered, my lord. They may examine it. And
DC will consider. That direction
that may
go
be
to DC,
considered.
my
And
lord.
Yes, Ms. Das?
regarding
Yes, if anything he is to,
Where is your representation?
that is, Lordship will get at page 29.
but it's not fishery, it's a whale, my lord.
No, no, whale was that amount has been paid. That is paid, my lord. Amount is paid,
1,000 paid.
This 29/9/2015 representation.
my lord. And this was forwarded also, my lord.
This is to the additional deputy commissioner.
Additional Deputy Commissioner.
And then
And this was forwarded by the Deputy Commissioner to Circle Officer, page 31.
2610. Yes.
Page 31 was forwarded, but nothing has been done. And
Shall
he
I
has been-
dispose it of?
Lordship may
Sir,
dispose it.
directing the deputy district commissioner.
Well,
Look into the grievance. If anything is there, is there. I will not make any comments on anything
Ma'am.
else.
it is written as
And-
Tua, my lord, well.
No, well, I have got.
7,500.
Yes, I have got.
Then 1,000 only, nothing
No,
remains.
no, 8,500 for fishery.
Lordship, if anything remains. my
That's
lord.
what.
Lordship
You see,
may
it
be-
is very difficult.
Yes, my lord.
The only reason why I am thinking of disposing is because you see this matter is of 2019 and these representations of 2015. No, there is no
My lord.
point of keeping these matters pending. If something has to be done, let the DC do. If the DC finds nothing remain, he'll end it. Let there be some conclusion and clarity in the matter, isn't it?
Yes, that's the thing. Because the mechanism is not before this.
True, Mr. Sharma.
I agree with that.
Heard Mr. K.R. Padgiri.
KM Haloi.
Huh?
KM Haloi. 10 million. Item number 10.
Item 10.
Yes.
Your name?
KM Haloi.
Heard Mr. K.M. Haloi, Learned Counsel for the petitioner. Stop. Also heard Mr.
B. Sharma.
B. Sharma, Learned Standing Counsel, NF Railway. and MS Udas, learned additional senior government advocate for the state respondent.
My 3, 4, and 3, 4, 5, and 7.
Stop. By filing this petition under Article 226 of the Constitution of India, comma, the petitioner is seeking direction for payment of adequate compensation for acquiring his land by the railway for construction of new BG railway line from Moinaguri to Jogi Chok Hopa, and also pay compensation amounting of rupees 8,500 along with interest at the rate 18% per annum from the date of acquisition of the fishery stock. It appears that the petitioner has filed a representation on 29/9/2015 within bracket annexure 7 to the writ petition before the additional deputy commissioner within bracket revenue Bongaigaon requesting release of compensation value, release of compensation
For the fishery only.
for the fishery.
8,500.
For the fishery amounting to rupees 8,500. Stop. It further appears that the aforesaid representation of the petitioner was forwarded to the office of the Circle Officer, Boitamari Revenue Circle by letter dated 26/10/2015, which is within bracket annexure 8 to the writ petition. Stop. Admittedly, the aforesaid, no, not admitted. However, nothing has been done from the office of the district administration as regards the aforesaid representation filed by the petitioner till date. Stop. In view of the above, this court is of the considered view that this writ petition can be disposed of with a direction to the respondent number
Deputy Commissioner 3.
Respondent number 3
3 and 4.
to the respondent numbers 3 and 4 to dispose of the representation of the petitioner dated 29/9/2015 within a period of 2 months from the date of receipt of the certified copy of this court's order. Stop. Disposed of.
Much.
I am not recording anything else. Not required. Needless to clarify that a copy of the writ petition along with the certified copy of this court's order be furnished to the aforesaid respondent authorities.
Much.
Disposed of. I think you can change your...
Well, in this case, the petitioner has challenged the jurisdiction of the authorities, more particularly that of the respondent number 3.
Nothing has been filed.
My lord.
You have taken time.
Lordship.
It has been listed after so many times,
Yes. So let them...
My lord.
Right.
I'll also in the meantime take instruction whether petitioner is still working. At the time of filing, he was 58 years, my lord. Now he must have retired from the post. I'll take that instruction.
Mr. P. Datta.
And T. Chakravarti.
Mr. P. Chakravarti, Learned Counsel for the petitioner, seeks 2 weeks' time to obtain instruction from the petitioner as whether anything still survives for adjudication in the instant writ petition. Stop. In the meantime, MS Udas. State respondents are at liberty to file their response, if any.
Obliged.
List accordingly.
May it please your lordship.
Yes.
Lordship, on last occasion they were...
Some affidavit was required
Yes,
to be
yes,
filed.
Your lordship.
Lordship, on behalf of PWD, I have received instruction. As per the PWD record, Lordship, the project was only sent to the PWD department by the WPT department for approval, and the rest and the project was of WPT BC department, Lordship. The amount has to be paid by them.
So you put it by way of an affidavit then?
Yes, Lordship. That.
Mr. B. Chaudhary, Learned Counsel for the respondent, submits that the instruction sought for has been received by his office, comma. However, he seeks some time to file the same by way of an affidavit. Stop. Prayer allowed. List this matter after 2 weeks on a date to be fixed by the registry.
My lord, the concerned authority also should file an affidavit regarding this.
In the meantime, other respondents are also at liberty to file their response, if any.
Deeply obliged, your lordship.
Yeah, please, your lordship.
Yes.
Matter relates to the contractual bill of...
Here also you were supposed to file
Yes,
affidavit.
Lordship, I have received their communication. They have sought for some more time. They have to collect the documents from the Karimganj division.
Mr. B. Chaudhary, Learned Counsel for the respondents, assures that the information sought, don't say assures, submits that he has received a communication dated
26 June 2010.
26/06/2024 from the authorities concerned, requesting further time to furnish the instructions as sought for by this court. Correct?
Yes.
Stop. Prayer is not opposed. List this matter after reopening or sort of date on such and such date.
Obliged.
Obliged.
Yes, Ms. Ghosh.
May I please your lordship?
Nothing filed in
No,
this matter?
not yet.
The
Not
2020 matter?
They have not filed.
Yes, Ms. Das.
Yes.
ये matter.
I think your because this is for regarding compensation for
yes.
unlawful detention.
Detention, yes.
So your response would be
Necessary, my lord.
valuable.
My lord, my lord.
9 years and fundamental
Yes.
rights is violated.
Please take it up with the with the concerned office.
Whether we are particular, we have
Government-
not shown,
Government
not shown
of
in the
Assam.
cause list as well as file is also not available.
Government, State of Assam, represented by Chief Secretary to the
My lord,
Government
my
of
lord,
Assam.
my lord.
So it is
Respondent
not
number
shown.
two.
My lord,
No,
not
but
shown
but I think it's she's right. It is not shown in the cause list. So that is
Understood.
why she doesn't have the file.
We don't.
Yes, I have understood. What I'll do, Ms. Das, I will give you the time, but in the meantime, you please have a look with the file in case anything is to be filed, because court's copy indicates nothing has been filed.
Lordship,
Yes,
lordship,
All right?
and
So
lordship.
you take it up, because unnecessarily, otherwise on another date,
Lordship is correct.
all right?
Lordship.
Heard MS D Ghosh, right? D for Delhi.
Yes.
MS D Ghosh, Learned Counsel for the petitioner. Stop. Also heard MS U Das, Learned Additional Senior Government Advocate for the state respondent. Stop. It appears that the MS U Das, Learned Additional Senior Government Advocate, seeks 2 weeks time to file the.
Let it be, my lord. First week of August,
All right,
my lord.
I'll give you that. 2 weeks time to file the return in the matter. Stop. Prayer allowed. List this matter. Yes, date 2nd week of August. 7/8/2024. Stop. Let registry reflect the name of
GA Assam.
GA Assam in the cause list.
Lordship.
Deeply obliged.
Please, your lordship. Lordship, this is a case of electrocution, lordship.
Electrocution, yes.
Yes.
No report, my lord.
Yes, I affidavit, Ms. Das, electrocution case.
Item 15.
15.
Matter was last listed in the year
The 21 matter.
My lord, I have found, my lord, instruction, my lord, not report of, my lord, the...
No, then you get the report and you file it. MS Yudas, learned additional senior government advocate, seeks 2 weeks time to file the necessary report of the chief electrical inspector, Assam, right?
Yes.
Stop. Prayer allowed. List this matter on such and such date, August 2nd week.
Deeply read.
14 August.
Oblige.
In this case, I have received instruction, my lord, to file additional affidavit due to subsequent development.
There has been some development, Mr. Das.
Yes, my lord.
All
Because,
right.
my lord, petitioner
All right.
is Mehdi.
As prayed for by Mr. H. Das, learned counsel for the petitioner, list this matter after 3 weeks to enable the petitioner to bring on record the subsequent developments that has occurred in the matter by way of an additional affidavit. Stop. List. Do you want a date? List the list after 3 weeks on a date to be fixed.
Because it need violence, my lord, effective.
Okay. Yes, Ms. Bhattacharya.
As per the last order, the respondent was supposed to file
Yes,
the
who are the
affidavit.
respondents? GST.
GST.
Yes, Mr. Kayal is not in court. Any juniors? Mr. K. Gugu is here. Last time he had appeared for 1, 2, 3 and 4. Can you ask one of your colleague to call for Mr. K. Gugoi as well as Mr. S.C. Kayal? We'll take it after some time.
Yes, sir.
May I please, Your Lordship? Lordship, in this case, the conducting counsel is on lags, Lordship.
May it please your lordships, I am appearing for respondent number 4, 5, private respondent number 4, 5 and 6.
4, 5 and?
4, 5 and 6.
4 has filed an affidavit. Anybody else is appearing in this matter?
I have already filed affidavit, my lord, for
3.
respondent number 3.
You don't want to file a rejoinder?
Lordship, then I may be allowed to file.
Yes, you file your rejoinder.
Yes, Lordship.
Yes,
my lord.
He has a right to file a rejoinder
My lord.
as prayed for by Mr.
P. Majumdar, Lordship.
P. Majumdar, learned counsel for the petitioner, list this matter after 3 weeks on any date to be fixed by the registry to enable the petitioner to file rejoinder against the affidavit in opposition filed by the respondents.
Your lordships, in many last occasions, the petitioner has taken time
All
for
right.
filing.
Yes.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship, we have received the affidavit in opposition. Therefore, Lordship.
Rejoinder?
Yes, Lordship.
As
My Lord,
prayed,
small
Mr.
submission,
Samaria, why are you all objecting to the
My
right
reason
of the
is that,
petitioners to file the rejoinder?
Quoted.
He has a right.
I would not oppose. Simple reason is that, my lord, there is a huge liability against him where we have given him said, my lord. Neither is paying a single penny, my lord. And
I'll give them a short date. As prayed for by Mr.
N. Brahma.
M.
N.
N. Burma.
Brahmo.
Brahmo learned counsel for the petitioner, list this matter second week after reopening. Date. List this matter on 24/06/2024 to enable the petitioner to file rejoinder against the affidavit in opposition filed by the respondent number 4 and 5. Stop. Needless to
my lord, attempt may be made to dispose. My lord, the property is a public property, my lord.
In view of the urgency canvassed by Mr. S. Samoria, learned counsel for the
AIDC, my lord.
AIDC standing counsel.
AIDC, my lord.
Standing counsel.
Yes, my lord.
Learned standing counsel AIRDC.
IDC, double I.
AI.
IIDC, my lord. Double I, my lord.
Okay. AIIRDC, an endeavor shall be made to dispose this matter on the next day.
My lord.
Yes, pension.
Yes. Lordship, I am appearing for respondent number 1.
Where is the petitioner?
Yes.
No one is appearing. It's a pension matter, very difficult. None appears for the petitioner when called. List this matter after 2 weeks on a date to be fixed by the registry. Yes, R6. Who is appearing for respondent number 6? None appears for the petitioner when the matter is called. List this. Are you appearing in this matter? Yes, your name is there, Mr. Akan.
Yes.
Why are you so lost?
I am court number 30.
Yes, are you appearing in item number 22?
Yes, 21.
21 is over.
21 is mentioned.
21 is already over. 2 weeks.
After 2
Yes. Yes.
Lordship, pass the order.
Huh?
Lordship, kindly fix another date.
No, I shall fix another date. But Mr. Akan, why are you not even knowing why this matter is being listed today? Respondent number 6. Who is appearing for R6? They were supposed to file a counter affidavit. What happened? Even state government.
My love.
Why nobody is aware what is to be done in the matters? This court needs to do all the homework for you all.
Lordship, correct.
I was in court number 13.
That's all right, Mr. Akan. Ms. Das?
Forest is party here, my love.
Yes.
Forest, finance, my love.
So where are they?
Forest
They
is the
were
main
supposed
party
to
here, my
file
love.
affidavits, bring
Yes.
the report on record.
Yes, madam.
No one is here. Heard Mr. S.I. Akan, learned counsel for the petitioner. Stop. It appears from the last order dated 16/6/2023 that
Yes, madam.
Ms. Das,
My love.
in the last order, Mr. Goswami had appeared. Yes,
Yes.
Mr. Goswami, I think you had appeared
My love.
for the respondent number 5, state government, and you had submitted that a report dated 14/3/2023 from the respondent number 6 is received, and therefore you wanted time to bring the report on record. What has happened, Mr. Borthakur?
Lordship, here the representation is addressed to the DC. The Forest Department also, Lordship, releases the amount, but here the representation is to the DC, who is also empowered to release that ex gratia amount.
This is relating to ex gratia.
Ex gratia, Lordship.
Then I'll dispose it off.
That may be done,
Lordship.
Where is that representation? Because no, but last occasion some report was given. You see, why don't you all take the instruction? Report is there at page 46.
Lordship, our application at page 26. And another application at page 28, Your Lordship. In this case, Your Lordship, what happened? The husband of the deceased had expired due to attack by the wild animal. That is elephant, Your Lordship. And thereafter...
Anyway, since nobody is aware about the case, let me fix this after the vacation.
Lordship.
As prayed for, list this matter at the
Deeply.
Yes. Next, please. Yes, Ms. Bhattacharya?
Lordship, I tried to contact Mr. S.C.K.
No, Mr. Gogoi is there?
Mr. C.K.S. Bora's name is reflected. He is there also.
In the cause list?
Cause list also.
Are you appear because you had accepted notice?
Probably that day nobody was there, right? That's why also.
So what is to be done?
So Lordship, if any difficulty is not there, any other day I will inform them.
Any other day. Any other day.
Heard MS A. Bhattacharya, learned counsel for the petitioner. K. Bhattacharya.
K. Bhattacharya.
K. Bhattacharya, learned counsel for the petitioner. Stop. However, there is no representation on behalf of the respondents. List this matter, reopening date.
Obliged.
22 to 21, null appears for the petitioner when the matter is called. List this matter on 19th 07/2024 with the remark in the cause list for dismissal.
May I please, Your Lordship? Lordship, in this case, my lord, the similar order has been passed in another case, my lord. It was tagged earlier, but in the last occasion, this matter has not listed along with my lord. I have placed the same impugn order, my lord. The fair price swap was different, my lord. My license was cancelled, my lord. Fair price swap license cancelled.
Oh, this is that shop. I think this court has disposed of IMFL.
Yes, my lord.
Oh no, fair price shop.
Fair price swap. Yes,
Mr.
my
Purva,
lord.
you are aware?
Yes.
The same order can be passed?
No, Lordship, in fact from
M. Setia was
from
appeared, my lord.
different shops, there are different anomalies that are being created.
Impugn order is the same, my lord.
Mr.
Impugn order is the same.
So what is the any changes in this order, or everything will remain same?
It remains same, my lord. Only the fair price swap.
Challenging
and
on the order is 22 to 23?
Yes, yes.
Respondent 6?
Yes, my
lord. Superintendent Food Civil Supplies and Consumer Affairs Silchar?
Yes.
Lordship, may I be allowed with some time to go through this order?
1 second. The license number will be different, I think?
Yes, yes.
Correct. What is
Yes.
the license number?
This one, my lord, this 2007.
2007
of 1993 to 1994, my lord.
1993 to 1994.
4, my lord.
Okay. Then, and the show cause, no, that date will be the same.
My lord, so
14/6/22.
I'm sorry, my lord, the license number of this case, my lord, 2209.
Different one.
License number of this case, my lord, 2209, my lord.
2209/1993.
My lord.
These are the information you must have on the tip of your finger.
Here is not.
Here is not mentioned.
My lord, that's
Not mentioned.
License number is 2009.
My lord, page 28 is my license, my lord. Page 28. Page 28.
Page?
28, my lord.
License number 2209.
Yes, my lord. Here, my lord.
So I will say 2209.
My lord.
Yes. And the show cause?
Show cause page 45, my lord. Impugn order, my lord. Page 45, my lord. The date is there, 22/02/2023 below. Page
20?
22/02/2023. Same, my lord.
No,
Same
this
code.
is the order, but there was. I'm talking about the show cause.
First show cause notice 14/6/22.
Okay, so that is the same.
Page number 29.
Okay.
Second show cause
And
notice.
your written reply is 16/6/22, and the suspension order is
My lord, my here 15/6/22 is my reply. 15/6, my lord, my reply. Suspension, my lord, next is 31/8/2022.
suspension is
31/8/2022.
31/8/2022.
2022.
You see, by saying similar order,
My lord,
you
yes.
shift the burden to us.
Yes.
Later on, I, along with my stenographer, has to dig the entire file for all these informations. Yes, and then after suspension,
Second show cause, my lord, 31/8/2022.
31/8/2022. Yes.
I have
And then
replied on 14/9/2022.
14/9/2022.
Yes, my lord.
And then hearing
Hearing, my lord, page 41, my lord.
on
19/10/2022, my lord.
19/10/2022
Page 41.
at 2:30 p.m.
At my lord 2 p.m. my lord. This
At
one.
2 p.m.
2 p.m. my lord. My lord, hearing date is 20 October, my lord. The notice for hearing is 19.
All right.
My lord.
So it's the same time. And then now the order of cancellation.
Order of cancellation, my lord.
I think it's the same.
my
22.
lord. Page 44, my lord. 22.
Yes.
02/22.
Your name?
My lord. S. Hazarika, my lord. petitioner is Muslauddin Laskar. Your fair price of naam ki asle?
Additional affidavit is filed here.
Yes, affidavit has been filed by respondent 4 and 6.
Additional affidavit filed on same day.
22/11/23. So 2011,
Yes,
2011,
23/11, same day. So I think the rest of the order will remain same.
Yes.
Alright, just do one thing. I have made the pencil corrections. Have a look at it. If anything, any changes to be there, do it and give it. Mr. Borwa,
Yes.
you've looked at it?
I have
I
gone
think
through
it's the
only
same
with
thing.
regard to not furnishing the report.
Correct. So, disposed of.
I'm deeply obliged.
Please return it to my
I
steno.
have extra copy.
No.
No, I'll
Mr.
go through
Chaudhary,
the correction, madam.
just check the pencil correction.
Yes, madam. As per the date.
Mr. Borwa, please give it to them for the. I have put. Let them check the verify the pencil corrections. All right, next matter, please.
Deeply obliged.
24 disposed of. Sharmila, it will be the এটা অৰ্ডাৰ দি দিবা আৰু খালি তেওঁলোকৰ ওপৰত নামটো চেঞ্জ হ'ব এই মই পিছত দি দিছোঁ সেই দুটা নাম আগত দি দিবা
Lordship, here in this case, Lordship, affidavit of Revenue Department, Lordship is very.
Yes, Ms. Borman had taken time, Mr. Borwa, last time.
Yes, we are yet to have our instructions.
How much time?
Let it be after the vacation.
And revenue is also there.
Yes, Lordship.
So you both then it take time because Mr. S. Borwa, learned government advocate, and Mr. A. Bhattacharya, learned standing counsel revenue, seeks further 3 weeks time to file their return in the matter. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Give that.
Ex gratia.
My lord, extremist killing, my lord. Father of the...
This has come after 23. Yes, Mr. Borwa. The question of maintainability is also kept open.
Yes.
You will have a look at it. I'm posting it after the vacation.
Even, my lord, the deputy commissioner already submitted.
That's right, but the last occasion, it appears your maintainability has been questioned by the respondent. So I'm as prayed for, list this matter, reopening or week to date on such and such date.
Yes. I'm on.
Yes, Ms. Chaudhary.
Lordship, I'm appearing on behalf of respondent number 3. The matter related to victim compensation and in the interim an award of 1 lakh was granted to the petitioner. But unfortunately, due to paucity of funds, it could not be cleared. I filed my affidavit to that effect. In fact, there's a PIL which is pending before the Honorable Chief Justice with regard to the funds having not been cleared by the government to the SALSA. And Lordship, so the status as of right now is that an interim compensation was granted, but that has also not been able to be paid to the petitioner. The final compensation was kept pending due to the pendency of the trial, which was still going on.
None appears for the petitioner when the matter is called. Stop. MS R.S. Chaudhary, learned counsel for respondent number
3, Your Lordship.
Respondent number 3 submits that though interim compensation,
yes,
though interim compensation, some amount of interim,
1 lakh.
though interim compensation amounting to rupees 1 lakh has been paid, has been released, has been granted to the petitioner, comma, the same could not be released due to non-availability of funds. Stop. She further submits that as regards the issue of fund, comma, a PIL is pending adjudication before the division bench of this court. Stop. List this matter after 3 weeks on a date to be fixed by the registry.
Deeply obliged.
Well, again, item number 29 for respondent number 4 and 5, I have got the instructions below. I pray for 2 weeks time for filing affidavit. No, let it be after the vacation.
Mr. Dina, as prayed for by Mr. Dinath, Learned Senior, Learned Standing, you're appearing as Learned Standing Counsel, APGCL, comma, list this matter after 3 weeks on a date to be fixed by the registry to enable the APGCL to place the instructions received by way of an affidavit. By way of an affidavit.
Lordship, Dima also has to file the affidavit also.
Needless to clarify that the other respondents are at liberty to file their return as well in the meantime, if they so desire. Then appears for the petitioner where the matter is called list on second or third day after reopening. The case diary you have received?
Yes,
Retain the case diary.
30 and 31.
Retain the case diary. 30 and 31.
My lord, updated case diary not received.
Await up-to-date case diary. List this matter again on?
On my lord, 32.
32. Are you appearing?
32.
No, I am appearing for 30 and 31.
That is already done. We have fixed it on 18.
Case diary
Case diary is there, but no one was there for the petitioner.
Actually, the display board was
All right.
related,
Just
that's why.
wait. To cancel that order, 30-31. Just wait. Just sit there for a minute. Yes.
On my lord, 24/7, he is in interim. Item number 32, my lord.
32 ki likhile list again on
24/7.
24/7/2024. Interim, if any, shall continue till the next date of listing. This is 34. 32.
Yes.
And 33, someone is there?
Yes, 33 case diary.
Yes,
After 33, call the other guy.
Lordship, I have appeared before the IO.
33, you have appeared?
Yes, Lordship.
Yes.
He appeared, my lord, statement recorded.
Yes.
But there are sufficient material against the accused person.
What about the antecedent? What about whether she will, whether about fleeing from justice?
He appeared, statement recorded.
Those things, nothing is there otherwise, isn't it adverse?
Material is there again because already.
Material relating to the involvement
Because
in the offence.
my lord, to tell one.
Mr. Bhattakur,
Yes,
you're not hearing what this court is saying.
Yes,
I'm
sir.
saying you have materials as regards the offence.
Yes, sir.
But as regards the antecedent, fleeing from justice, there is nothing. Isn't it? Sharmila, wait. As heard, MST Som, Learned Counsel for the petitioner, stop. Also heard Mr. P. Bhattakur, Learned APP.
My lord, earlier rejected by your lordship.
APP for the state respondent, stop. Where is that order?
That order is page 12, my lord.
Page
12.
But this time, since they have already appeared, isn't it? This is an application under section 438 of the Code of Criminal Procedure 1973 for granting anticipatory bail to the petitioner, namely Kanjit Kolita, who is apprehending arrest in connection with Nalbari PS case number 32/2024, registered under sections 120B, 143, 144, 341, 326, 307, 436, 353, 427 of IPC 1860. Stop. The case of the prosecution in brief is that on 31/2024, 4 persons who were sitting inside the car were badly assaulted by the villagers with bamboo stick and lathi with intention of killing them in suspect of cow theft. It is further alleged that the police personnel were also attacked and the government vehicle was damaged. Stop. Pertinent Next paragraph. Pertinent that this court earlier, by order dated 22/3/2024, rejected the prayer for anticipatory bail. Stop. Pertinent more that by order dated 10/5/2024, this court had granted interim pre-arrest bail to the petitioner, subject of course to conditions. Stop. Next one. Mr. P. Borthakur, Leonard APP, CD called is placed before this court. Mr. P. Borthakur, Leonard APP, submits that the petitioner, in view of the petitioner, as per the order dated 10/5/2024 passed by this court earlier, appeared before the investigating officer, and his statement has also been recorded under section 161 CRPC. Stop. He further submits that the case diary reveals that there are materials available on record implicating the accused for the offence alleged. Stop. He, however, fairly submits that there are no materials adverse to the antecedent of the petitioner and no material whatsoever available in the case diary to suggest that the petitioner shall flee from justice in the event he is released on anticipatory bail. Stop. Next part. Considering the fact that the petitioner is cooperating with the investigation, this court is of the considered view that custodial interrogation may not be justified for the ongoing investigation. Stop. Accordingly, the interim pre-arrest bail granted with the order dated 10/5/2024 is hereby made absolute, subject of course to the following conditions. 1, 2, 3 disposed of.
I'm deeply obliged. Deeply obliged.
Yes.
Well, this is an application under section 439, and the petitioner is behind the bar for last 38 days.
Last 38 days?
38 days. My lord, the item number 31 also same, my lord, from the same FIR, my lord.
In 31, how many days?
Same
38 days.
38 days.
My lord, in this case, they surrendered, both the petitioners surrendered before the learned court below, my lord, on 21/5/2024, my lord.
21/5/2024. Surrendered.
Yes, my lord. Order is at page 27, my lord. Annex 2, my lord.
Yes.
My lord, they surrendered before the, my lord, learned CGM, my lord. Thereafter, they were sent to the jail custody. And after 2 days, my lord, they were taken by the police for police custody.
Earlier, I have rejected.
My lord,
No, my lord.
Regarding to these petitioners, my lord, your lordship has not rejected.
But similar. This
Regarding
is that land matter.
Yes, my lord.
Where these two were, I think earlier these two petitioners were.
No, their elder brother was, my lord.
My lord, I am not aware. Maybe they filed earlier anticipatory bail application. That
my
may be
lord,
rejected by
their elder brother was granted bail by this honorable court, my lord.
All right. Where is the FIR?
FIR, my lord, page 16, relevant portion at page 20.
Relevant portion is
At
at
page 20, my lord.
Yes.
May I read, my lord?
Yes, it is very. I cannot read it.
Yes,
it is
yes,
not
my
legible.
lord. Printing is very bad, my lord.
How? But how
Your
this
lordship
copy?
may kindly come to. Yes, my lord, it is very difficult to, my lord, not legible, my lord.
May I read, my lord?
Yes, yes.
Yes, my father left Prabhat Chandra Sharma, who was a renowned educationist and freedom fighter, purchased a plot of land measuring 1 kotha 10 lesa covered by Dag number so and so of Ulubari Moza, registered number, sale deed number so and so, out of total land measuring 2 biga 2 kotha and 8 lesas from one late Harikanta Bormon. My father, late Prabhat Chandra Sharma, never sold the land. He expired on 15/1/2000. Surprisingly,
My lord, gist of the case is that, my lord, there are 3 complaints filed against the present accused persons before the my lord, district commissioner, that these persons are involved in, my lord, fraudulently, my lord, grabbed the land of the, my lord, these persons, my lord. Thereafter, my lord, one inquiry was conducted by one IAS officer.
Do you have the copy of this court's order?
After that inquiry,
do
my
you
lord.
have the copy of this court's order?
Yes, my lord. It is on page number 67, my lord. He was the main accused in this case, my lord.
Who was the main accused?
This person, my lord, who was granted bail, my lord, by this honorable court, my lord.
Anup Oja.
No, my lord, Zakir Oza, my lord. Page 67.
No, but the specific case is that one Anup Oja and his brother Zakir Oja.
Zakir Oza and
another
occupied
Nipul
the
Oza.
said plot of land on 19/1/19. And the other person's name is?
My lord, one Nipul Oza and, my lord,
his name is not there in the FIR, Nipun?
my lord, in
Their
the
name
FIR
is not there, my lord. Only, my lord,
it has come out during investigation, right, Mr. Borthakur?
No, my lord, during the in all the 3 complaint petitions filed by the 3 aggrieved person, my lord, the name of the present petitioner is there, my lord.
FIR is the same, my lord. FIR is the same.
Later on, after, my lord, inquiry, my
But
lord.
he is the brother. It appears that this court has granted
bail, my lord.
Bail.
Yes, my lord.
So it
These
doesn't
persons-
make any sense for not granting. They are on the similar, unless of course you have something very serious.
Moreover, my lord,
Otherwise, my lord, matter is serious because, my lord,
Yes,
this
you see,
person,
this court has
because
already.
after conducting inquiry,
This
my lord,
court has
FIR was-
already taken care of that submission
Yes.
of yours in paragraph 17 of the earlier order.
Yes.
Undoubtedly, the offence is grave.
Yes.
However, the object of the bail is not punishment, but to secure the appearance of the petitioner during his trial by reasonable amount of bail.
Yes, my lord.
With times, this very thing is. One is trying to forget this.
Yes, ma'am. Only
Just
considering-
because it is grave,
Yes, ma'am.
one keeps on submitting that the bail should not be given. It's not just the gravity. You have to see everything. Fleeing from justice, antecedents.
Yes, ma'am.
Anyway.
Considering length of detention and substantial progress of the investigation.
Similar order, I'll give it. Heard MS?
NS Thakuria.
NS. NS Thakuria, Learned Counsel for the accused petitioner. Also heard Mr. P. Borthakur, Learned APP for the state respondents. Stop. This is an application under section 439 of CRPC 1973 seeking regular bail of the petitioner
Sri Anup Oza. Please.
Sri Anup Oja, who surrendered on 21/5/2024 in connection with Crime Branch Police Station case number 03/2020/2024 registered under sections 120B, 420, 468, 471, 409 of IPC. Stop. The case of the prosecution is that an FIR has been lodged by one Shri Hirendranath Sharma on 28/1/2024 alleging inter alia that his father purchased a plot of land measuring 1 katha 10 lecha covered by Dag number 1129 and patta number 1424 of Ulubari Moza.
My lord, I would like to point out, my lord, initially FIR was not filed by these complaint persons, my lord. 3 persons filed 3 complaint petitions on the same date before the district commissioner. Thereafter, my lord, district commissioner, my lord, conducted an inquiry through an IAS officer. Later on, after conducting the inquiry, my lord, the deputy commissioner lodged this FIR, my lord, in the present case.
So that is that lodged by Shri
It is lodged by my lord Hirendranath Sharma, not by anybody else.
I am saying Hirendranath
Yes,
Sharma.
my lord.
Mr. Borthakur, let me dictate the order. If there is
Yes,
something, you
yes,
please point
yes,
it out
yes.
later. Ki likhila? Of Ulubari Moza, Vide registration sale deed number 2142 dated 31/08/1950 out of total land measuring 2 bigha, 2 kathas and 8 lacha from one late Harikanta Borman. Stop. It is the It is the specific case of the prosecution that this land was never sold by the said owner and he expired on 15/1/2000. Stop. It is the further case of the prosecution that that the accused petitioner, along with his brother, one Jakir Oja, occupied the said plot of land on 9/1/2009, and later on the informant came to know about it from his neighbors. Accordingly, a case has been registered. Stop. NS Thakuria, Learned Counsel for the petitioner, submits that in the year 2006, one Shri Utpal Chandra Das approached the accused petitioner to purchase a plot of land measuring 1 katha covered by DAG number 1129 of Patta number 1424. Don't write this. MS so-and-so Thakuria submits that the allegations leveled by the informant pertains to a civil dispute between the parties which has been adjudicated by a competent civil court within jurisdiction, and the same is pending adjudication before this court in RFA number 60/2015. Stop. She further submits that when the title of a land in question is itself clouded and in dispute, no act of criminality can be said to have been committed by the accused petitioner. Stop. Mr. P. Borthakur, Learned APP, on the other hand, strongly opposes the prayer for bail. He submits that the offence is serious and there are sufficient materials collected by the investigating officer against the petitioner showing the involvement of the accused petitioner in the offence alleged, and since the investigation is not complete, the petitioner may not be released on bail. Correct? Yes. Stop. I have heard the submissions made at the bar and I have perused the materials available on record. It appears that the petitioner has been languishing in jail since last 38 days. When was he last interrogated? It further appears that the petitioner was last interrogated on
Yes. I will point out, madam.
On such and such day, and since thereafter he has not been interrogated. Stop. It further appears from the materials available in the case diary that the investigation has substantially progressed.
On 31/5/24, madam.
31/5/24.
31/5/24.
It further appears that there is nothing adverse with regard to the antecedent of the petitioner and as regards fleeing from justice. Stop. Next paragraph. Undoubtedly, the offence is grave. Stop. However, the object of the bail is not punishment but to secure the appearance of the petitioner during his trial by reasonable amount of bail. Next paragraph. Considering the totality and facts and circumstances of the case along with the length of detention, This court is of the considered view that further detention of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, it is provided, next para, accordingly it is provided that the accused petitioner named above shall be released on bail on furnishing bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate Kamrup,
Yes.
within bracket M, under the conditions that, number 1, incorporate, indirect, disposed of. A, order to me, लिखित हो गया, page 67. Second is 33.
My lord, 31.
30 and 31.
30 and 31. 30
Yes,
disposed of, and in 31,
31
just-
name is different.
just
my
the
lord.
name to different.
Name is different.
disposed of.
Deeply obliged, my lord.
I'll just resume in 5 minutes. Who is the applicant? The applicant is absent. This is an interlocutory application.
Matter has become infractuous, my lord. He is not there, my lord.
But let him be there. None appears for the applicant when the matter is called. Stop. List this matter after 2 weeks. After 2 weeks. Yes?
Yes.
2 weeks?
After vacation.
After 2 weeks on a date to be fixed by the registry. But P5, Mr. Chaudhary, you are appearing
Yes, my lord. We are filing an affidavit in reply today, my lord.
in the interlocutory application.
No, my lord, in the main petition.
But who has filed this IA 2019? Item 35, right? East India
item 35.
Eastern Club.
2051. That is an IA for adducing additional evidence.
For? Adducing additional. You have filed it.
Yes, my lord.
So are you, or you have filed affidavit today in this matter?
My lord.
So I'll post it on another date then?
Yes, my lord.
And you're not pressing this IA at
No,
this
my lord.
moment?
Today, my lord, I am not.
Today you're not. Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. T.N.
M. Sharma.
Mr. M. Sharma. Mr. M. Sharma, for the petitioners, submit that a rejoinder has been filed today.
Yes.
I-26 so and so. Stop. However, the same is not on record. Let the registry verify and place the same on record. You have got a copy?
No, my lord. In fact, we could not
All right.
contact them. My lord will be serving today.
Ask your junior, Mr. Sharma.
Yes,
List this matter. You want to fix it?
Fees that will be
On such and such date after the vacation. Second week.
obliged.
All right. Yes, Mrs. Ayala, construction
to all
work.
earlier reports, my lord, a report has been submitted by Circle Officer my lord, on the basis of a last model report. Yes, this is totally contrary to all earlier reports. My
So
lord,
there are
your
two
lordship-
contrary reports on record.
No. Contrary report has been submitted
Contrary
by
report.
Yes. My lord, your lordship may see the main writ petition, page 21.
Yes.
This is the Circle Officer, my lord, report to Deputy Commissioner.
This matter, this IA is for what?
I am, my lord, for immediate, my lord, we restrain them to do anything in my land, my lord, which was settled in, virtually, my lord, the Land Advisory Committee has directed to settle the land in my favor. I was in possession of the land since some time, my lord. So, interim order is to be passed, my lord. Not
This
to do
IA
anything.
is for interim direction.
Yes, interim direction. In the IA, we have filed affidavit, lord. In the affidavit has been filed in the IA, my lord.
Restraining the opposite party so and so from carrying out construction works in the land. Whose land is this?
The government land, lord. Government land, but my lord, it was likely to be settled in my favor. I was in possession of the land. If you will also see the writ petition, my lord. According to our instruction,
One
they
second,
have
Mr.
the.
Goswami. Take your seat. Mr. Ayawala, this let me understand the grievance first. This land was initially supposed to have been settled with you. Correct? But later on they settled it with somebody else.
No, my lord. Here what happened, my lord? There is some dispute regarding dark number. My lord, dark number 360 was under my possession, and in 2014, my lord, report was circular clearly say that the land is under my possession, and it is not put to a national highway or river or anything else, my lord.
Where is that?
That is at page 21.
Yes. Translated version is there?
Yes.
20?
Translated copy.
20, right?
20, yes.
Yes. This is by the circle.
Sir. With due respect, I would like to inform you that Nilabja Bhuya, son of so-and-so, filed an application for settlement of a plot of land measuring 3 kara 10 licha.
You are reading from page 20?
20.
Yes.
Due respect, I would like to inform you that Nilabja Bhuya, son of Lake Pasan Bhuya, filed an application for settlement of the plot of land measuring 3 kara 10 licha out of the total land measuring 2 biga 4 kata 10 licha, polling as Radna 360, Jorhat East Avenue Circle, Jorhat so-and-so. It has mentioned that the applicant has been possessing the land and has been paying the...
I think there is some... you are reading from the writ petition.
Writ petition.
That is why. Because writ petition are filed with you, sir.
Page 21 of the writ petition. Page 21 of the writ petition. That is translated copy of the report of the circular.
Yes, yes.
With due respect, I would like to inform you that Nilabja Bhuya, son of so-and-so, filed an application for settlement of plot of land measuring 3 kata 10 licha out of total land measuring 2 biga 4 kata 10 licha, falling under Dag number 360, situated in Jost Avenue Circle, Jorhat, so-and-so, so-and-so. It is mentioned that the applicant has been possessing the land and has been paying Toji revenue in respect of the aforesaid plot of land. The land is not situated beside a national highway or any river, and no valuable tree is present in the said land. The applicant is business proposal. Therefore, the applicant filed the so-and-so is forwarded herewith along with the application filed by the test map copy of the Chitha valuation report. Test map is also approached, my lord. Now, on the basis of this, my lord, it goes to the Land Advisory Committee. That you will also find at page 23.
Just 1 second. So here the circle officer has admitted that you are that this land is settled with you.
Yes.
File an application for settlement.
Yes.
It has been mentioned that the applicant has been possessing the land.
Yes. That number 360.
All right. Yes.
Then, my lord, it goes to the Land Advisory Committee, page 23. In the Land Advisory Committee, my lord, if you will also come to page 24, item number 179.
Yes.
Nilabja
number
Bhuya,
360.
that
yes.
is, my lord,
Approved.
My lord?
Approved.
Approved. Approved.
Yes.
Then, my lord, again, it will also find at page 26.
Yes.
As I am requested to submit the zonal valuation certificate. My lord, this is additional deputy commissioner has said to the circle officer.
Yes. 360.
Yes.
But after approval, they are asking for the
yes.
zonal valuation certificate.
Yes, zonal valuation because value is to be fixed. Accordingly, my lord, valuation has been given by the circle officer, page 27.
Yes.
That value should be
3,50,000. Yes.
Now, you will also come to page 29, my lord.
Yes.
Then, deputy commissioner brought to the commissioner, my lord, for approval.
Yes.
For settlement. This is the letter. I am not reading it, my lord.
All right. Yes.
Then, the government, from the government again, deputy commissioner has been asked that, if you will also see, my lord, I am directed to return the proposal received from regarding settlement allotment of...
Where you are reading?
Page 30.
Yes, I am returned, yes.
Yes. In inviting reference to your letter subject cited above, I am directed to return herewith a proposal received from you regarding the settlement allotment of land in favor of Nilabja Bhuya. That the proposed land falls in a rural area as per section 3.1 of the land policy, that the so-and-so deputy commissioner of district is competent authority to allotment the land of so-and-so. So government says, my lord, that
deputy commissioner has already
can do it.
has all.
Yes.
No. The settlement that was given to you, that approved, that was done by which authority?
Land Advisory Committee, my lord.
Committee, and then it went to the Deputy Commissioner.
Deputy Commissioner.
Isn't it?
Yes.
The circle officer had written to the ADC
Yes.
that this is the valuation.
Yes.
And then there is a letter from the ADC.
Yes.
Deputy Commissioner, that 29.
Yes.
There he has already given it.
Yes.
With so and so here with proposal for settlement covered by so and so
Yes.
in favor.
My lord.
He's already proposed it.
Yes.
This place so and so, and our request to kindly take steps for according necessary approval for settlement. So then what happened?
Now, my lord, your lordship find
after the return,
at page 34, your lordship see, my lord.
Yes. 34.
Yes. Annexure 10.
Yes.
With due respect, I would like to inform you that in the years 2015, Nilabja Bhuya so and so applied for settlement of government ceding land measuring 3 Katha 10 Lisa under dark number so and so. Affirmation land is far from 1 kilometer from the Johar city. Proposed land is covered by dark number 360. Again, my lord, this is the report.
This is also in your favor.
My lord. Now, this is my lord. Page 36 is the main crux.
Yes. Returning.
Yes.
No, this is by the ADC. Yes.
This is by ADC.
This is what you have impugned.
Yes, my lord. This is.
Yes, please.
With reference to subject, I have honor to submit following information complaint petition submitted by.
Now they are referring to a circle officer report saying that the applicant holds no possession.
Applicant
holds no possession over the aforesaid plot of land.
Yes, they say that in 359 they have possession.
On dark number 359.
359.
But your was 360.
360. And moreover, my lord, if you will also see, the garden has lodged an information page 39.
Yes.
With due respect, I would like to inform you that Rajabari Unemployed Youth Society, on the guise of doing agriculture, have illegally occupied a plot of land falling under T Patta number 1, dark number 359 of village Toklai, T State, Gormur Moja, by constructing a tin shed and banner. In this regard, we have submitted one complaint to you since the land belongs to the Johar Tea community. It belongs to the Johar, it is not Silk Saprak land. The Health Department has also filed a complaint since we have donated a plot of land measuring 10 bighas to them in the year 1976. A plot of land measuring 2 bigha was given to Satra Sangramkar. The letter by which the aforesaid land was donated is enclosed here. In pursuance of our complaint, Your Honor had issued notice that so and so to Unemployed Youth Society to release it from encroachment. But till that, the land is under encroachment. Therefore, it is requested that the appropriate step may be taken in this regard. Well, so this is this report, they say that I am in position of 359 is wrong, my lord. I have given a reply also, I have given the photographs also, my lord. I am in possession of the land, there was my construction.
Now, by IA, what you are.
Well, I sought for, my lord, some interim relief, my lord, because in the main case they have not filed the affidavit. So, virtually, my lord, this affidavit may be treated in the main case also, my lord. This is the main.
No, you are seeking by this IA, you are saying.
They should not carry out
the construction work. What construction work is going on in flag number 360?
Well, they wanted to make some construction there, my lord.
But Mr. Goswami, from the papers that Mr. Sahewala had shown, it appears that consistently your office has been saying that they were in possession, and there is the committee has approved. The DC has already said that you send the proposal for approval. It is only later they said, the competent authority is DC, and that's why it has been returned. If these facts, because these are your documents, right? Now, after it came back, suddenly now there is a change in the strength. The circle officer earlier have said 360, and now they are referring to some 359. But we are concerned with 360. So, admittedly, in 360, as per your documents, they are in possession. And in that, you hear me out now, because today I am not disposing of this petition. So if that is the admitted position, this court can always clarify that no construction activities whatsoever can be carried out in DAG number 360, and we can keep this matter pending. You can have your hearing after 2 weeks, 3 weeks.
In DAG number 360, petitioner has no position, Lordship. In the DAG number 360, Lordship, petitioner has no position, Lordship.
But admittedly, your own documents are showing.
Subsequently, we have filed an affidavit, Lordship, in case.
Which one?
In the IA, Lordship, we have filed an affidavit.
And you have annexed a report of a circle officer.
Yes, yes.
So that is exactly what is being challenged.
Yes.
How can the circle officer give two different reports? You can't suddenly come and say I'm disowning the other report. It is the same authority.
That was earlier, Lordship. Subsequently, Lordship.
Correct.
They have Lordship's possession, Lordship. Subsequently. And it is reported to 2020, Lordship.
Show me just because I am not with you in this. Because admittedly, all these government documents consistently is showing that the petitioner is in possession of DAG number 360. And only once it was returned back, they mentioned something about 359.
Yes.
This court is not right now concerned with 359 because their prayer is relatable to DAG number 360. Correct? Now, which is the document that you want to say that he is not in possession?
That NXIA of our affidavit, Lordship.
In the writ petition?
No, in the miscase, Lordship.
Why have you not filed any affidavit in the writ petition which is pending from 2022?
In the court directed us to file in the IA, Lordship.
No, IA is all right because you are objecting. But what about the averments in the writ petition? If you do not file any affidavit there, they will go unrebutted. Then this court will have no other option but treat it as an admission to the facts.
No, there is direction from the honorable court to file an affidavit in the IA, Lordship.
Actually, this 23 page affidavit in the IA.
Lordship.
এখন affidavit file করেছে নি government.
They file reply on the affidavit.
No, but those are not there.
Page 20 of the IA.
Oh, it's there.
Yes.
You have filed affidavit in reply, 2 affidavit in replies.
They are repeating opposition, my lord.
Affidavit you are referring is the one of R325, Mr. Goswami?
Oh, yes, yes.
By one Monojit Borkotoki?
Yes, Lord.
Which page?
Page 20, Lord.
Yes. This, yes, I would like to inform you that
Next sentence. As per land survey report submitted by the President Nathmanda, it has come to know that the land under DAG 360 is not under the possession of Sri Nilabja Bhuya. He is a petitioner also. And said land is now covered with jungle and there is an abandoned house built by the tea state.
Then on the earlier occasions, how it was said that this he is in possession?
Let's be direct to circuit officer again, let's verify, let's.
But in the meantime, we will make it clear that no construction in DAG number 360. If it's a jungle anyway, there will be no construction. If you go by your second document, it says is covered with jungle. Then where is the question of any construction there? Isn't it? No. Mr. Sahewala?
Yes, sir. It is this report was 2020 launch.
So you mean to say by now the jungle have been all cleared?
Maybe
since there are two contrary reports, maybe some inquiry is to be done.
Logic.
Now, who shall do this inquiry? Until the inquiry is done, we will say no construction activities. We can, with that direction, we can, I think, dispose of your eye. No, what circle officer? Two circle officers have given two reports which are contrary to one another. Now you want another third circle officer to do a report?
ADC,
somebody superior will have to do it.
ADC will be directed.
Isn't it? Otherwise there is no difficulty in directing the circle officer. But two has already... Alright.
The circuit officer believes the report of the Lat Bandal Lordship. If circuit officer himself visited the spot, Lordship.
No, I understand, but now there are two circle officers' report. One says he is in possession, and if you have seen, everything was done. And suddenly now this circle officer's report comes in 2020, which says it's a jungle.
So ADC will go.
ADC, right? You hear the dictation. If any changes to be done, you let me know.
Well.
So the IA can be disposed of, right? Heard Mr. G.N. Sayawala, learned senior counsel, assisted by MS K. Bhattacharya, learned counsel for the petitioners, for the applicants. Stop. Also heard Mr. N. Goswami, learned government advocate for the state respondent, and MS N. Bordoloy, learned standing counsel, revenue and industrial management, industries management department. Industrial.
Disaster.
Oh, sorry. I'm not being able to hear what you're saying. Disaster management. By filing this interlocutory application in WPC number 1347 of 2022, the applicant is seeking interim directions, I will say.
Yes.
You are not using the word interim, but this must be for interim, isn't it? That is the relief.
IA for interim, madam.
Seeking interim directions to the effect restraining the opposite parties from carrying out construction works in the land measuring 3 katha 10 lecha falling under government dag number 360 situated at Moza Garmur Toklai Tea Estate under Jorhat East Revenue Circle in the district of Jorhat. Stop. The grievance of the petitioner is non-finalization of proposal of settlement of 3 katha 10 lechas of government khas land under dag number 360 of Moza Garmur Toklai Tea Estate in favor of the petitioner. Stop. It appears for the parties and peruse the documents, peruse the materials available on record.
My lord, with your lordship's permission, may I leave, my lord?
Yes. It appears that on 9/6/2014, the circle of the jurisdictional circle officer proposed before the office of the Deputy Commissioner Jorhat for settlement of the aforesaid of the subject land, i.e. falling under dag number 360 in favor of the petitioner, the applicant. Thereafter, on 8/5/2015, the Jorhat Subdivisional Land Advisory Committee in the meeting held approved the aforesaid proposal in favor of the applicant, which appears at serial number 179 of the minutes dated 8 May 2015. Stop. It further appears that the office of the Additional Deputy Commissioner within bracket Revenue Jorhat by letter dated 28/7/2015 submitted before the circle officer, jurisdictional circle officer, the zonal valuation certificate of land for settlement in favor of the applicant. Pursuant to the same, the jurisdictional circle officer by letter dated 4/12/2015 fixed the total valuation for the subject land at rupees 3,50,000. Thereafter, the office of the Deputy Commissioner Jorhat by letter dated 23/5/2016 submitted proposal before the office of the Commissioner Secretary, Government of Assam, Revenue Disaster Management Department in favor of the applicant. However, the office of the Revenue and Disaster Management Department returned the aforesaid proposal to the office of the Jurisdictional Deputy Commissioner with the remark that it is the Deputy Commissioner of the district, as per the relevant land policy, competent for allotment / settlement of land to the indigenous landless persons in the rural areas. And accordingly directed the jurisdictional district commissioner to take necessary action for settlement / allotment of land in favor of the applicant. However, pending finalization of the said settlement in favor of the petitioner, since some encroachments have been made in the subject land and some constructions have been started, the instant interlocutory application has been filed. In the instant interlocutory application, respondent numbers 3 to 5 has filed an additional affidavit on 18/4/2024, wherein they have enclosed a report of the circle officer dated 31/8/2020, wherein it is stated that the petitioner, that the applicant / petitioner is not in possession over the subject land falling under DAG number 360 of Toklai Sahabagisa Gaon. Since the controversy is now as regards the possession of the applicant over the subject land falling under DAG number 360, wherein this court finds that there are two reports of the jurisdictional circle officer, one in favor of the petitioner, one in favor of the applicant / petitioner, and one against, this court deems appropriate to dispose of this to dispose of the present interlocutory application by directing that an inquiry be caused by the Office of Jurisdictional Deputy Commissioner Revenue Jorhat as regards the possession of the applicant over the subject land falling under DAG number 360 of Toklai Chabagisa Gaon. So and so, and until and unless the said inquiry is completed, no construction activities shall be carried out in DAG number 360. In the land measuring 3 Katha 10 Lecha falling under government DAG number 360, situated at Mauza, Garmu, Toklai Tea Estate under Jorhat East Revenue Circle. Stop. Needless to clarify that the exercise as indicated above shall be completed within a period of 2 months with, from the date of receipt of the certified copy of the court's order.
If report finds that there is no possession lordship, then
the writ petition is pending.
The report shall be submitted before this.
With the above observation, this interlocutory application stands disposed of, and the writ petition you write. In view of the order passed in I number 3754 of 2023, list this matter after 2 months on a date to be fixed by the registry, wherein the state government shall apprise this court as regards the report submitted by the additional Deputy Commissioner Revenue, Jurisdictional Additional Commissioner Revenue, in terms of today's order. That is all right? I to dispose of.
May I please, Your Lordship? In this petition, National Highway is implicated as one number 4. Their grant is that without surveying the land in question in Dibrugarh district, National Highway has been constructed. But my submission is before Lordship that I have filed an IA regarding striking of my name as because we have not carried out any construction.
Earlier also one such application this court has allowed.
No?
Earlier,
another case. Because problems are coming now, you keep on coming. Ultimately,
but why the office of NHIDCL NHAI are being impeded? Because the work is executed? No.
Because what happened, my lord, generally people are thinking that construction by National Highway means it is constructed by National Highway. We have 3 wings, my lord. National Highway, NHIDCL and PWD NH division. That's why that particular area we have not constructed.
All right, if you have not constructed,
then paragraph 4 specifically I have mentioned.
You have nothing to do.
I have no objection.
All right. Paragraph
4 of my IA, categorically statement.
This is item 37. IA is IA 7.
Yes, my lord.
Okay.
24.
IA today in 37. Heard Mr. C. Borwa, Leonard, Standing Counsel, NHAI. Stop. And also heard MS P. Bora, Leonard Counsel for the respondent number.
I am for the writ petition.
For the respondent stroke writ petition.
I am for 4. Respondent 4.
No, but in IA you are the applicant.
Oh yes, applicant, respondent 4.
Applicant stroke respondent number 4. Then you write, this application has been filed for striking of the name of the applicant, I respondent number 4, the National Highway Authority of India, from the arrayed respondent in WPC number 8238 of 2017. Stop. It is submitted by, it appears from the averments made in the instant I that NHAI is not undertaking construction of NH-52B in the district of Dibrugarh, Assam, to which the writ petition relates, and as such NHAI is wrongly impleaded in the instant writ petition. Stop. It appears that the aforesaid averment is correct, and the work in question has, and the NHAI has no role to play in the work.
Yes.
In the
construction.
In the work in construct. In the work of construction, and as such cannot pay any compensation as claimed in the writ petition. Stop. In view of the aforesaid, the presence of NHAI is not necessary for the effective adjudication of the instant writ petition, and hence they have been wrongly impleaded. Stop. I allowed the name of NHAI represented by Secretary Government of India, New Delhi, G5 and 6, Sector 10, Dwarka, New Delhi, 110001 shall be struck off from the arrayed respondent in WPC number 8238/2017. Let amended cause title be submitted to the office of the registry for doing the needful. IA stands disposed of.
Right,
In the main petition, my lord, I will be allowed to make a PWD routes as a necessary criteria.
Sorry?
In the main petition, my lord, I may be allowed to file a impediment petition.
That you file?
Lordship.
In the main writ petition, you say MS
P. Bora.
P. Bora seeks 2 weeks' time to file necessary application for impediment of
PWD routes.
Of PWD roads. Stop. Prayer allowed. List after 2 weeks on a date to be fixed by the registry. 37 to disposed of. Yes.
Well, there is an order from this honorable court. My last day, Lord, may kindly see. The order dated 29/5.
Gail was supposed to obtain instruction.
Yes,
my lord. The work has been not yet. It is under process. It is started, but not yet completed, my lord. That is after vacation of stay order, because of some hindrance in the project, because of some technical issues. This is a substance, but they have filed. This is not related to this petition is not related with whether my work has been started or not. That is not the issue. The issue is that that entire first writ petition, the writ petition they have filed, this is dismissed for default, and in the interim, first they get a stay order. So I filed an interim application for vacating of stay order, and entire issue has been discussed over there. Then there no all the grounds have been discussed.
What is this IA?
IA. For conditional delay.
Well, this is for conditional delay for restoration of the writ petition.
This the writ petition was dismissed for default.
Yes, default. Yes.
I have filed an
You have objection to the restoration.
Yes, I have objection to the restoration because
where is that order of this? Why there was delay? How many days? 357.
Yes, my lord. I have stated the reason, my lord, paragraph 7, 8, 9 and 10 in that petition.
There are sufficient grounds. 357 days.
Yes.
Delay.
Yes. And they have not issued properly. What is the sufficient? There is no sufficient cause. They have contradicted their own statement.
No, my lord.
My lord, if your lordship say I go through my objections, my lord. They contradict statement. Every paragraph there is a contradict statement.
This court will not go by. It's a condonation application whether sufficient cause and
No
whether it has
sufficient
been
cause.
filed bona fide.
Means, my lord, one thing, just one paragraph.
Are you disputing the fact that this advocate died on 7/8/2022?
No. Advocate is not died.
Not died.
Not died.
He was advocate clerk.
He is advocate.
However,
died.
unfortunately, said advocate clerk died
Yes.
on 7/8.
Yes. What about the relation with advocate clerk?
No, but you see, they have given the sufficient grounds.
No,
Otherwise,
I'm just
it's the discretion of this court.
Discussion. But if you also go through paragraph 9, my lord, in their interim application, if you also go through that, the applicant his petition was unaware of the dismissal of the case till December 22. After knowing about dismissal of the case, applicant took some time to manage the legal expense and then came to his chamber first week of 24.
Yes.
So what about the delay? 1 year, what they are
He
doing?
explained. Before that, he said they did not know.
Yes, they did not
he
know.
He was not aware.
Yes, I
know only in December 22. He's explained.
No.
After that, he took some time for gathering the legal expenses. And then he has come and met the council.
No, my lord. They have contradicted their own statement, my lord. If you just read it, my lord.
All right, where is your affidavit objection?
Yes, my lord. In para 6, I have given everything. If you also go to para 6, you will understand, my lord, what I want to say, my lord. Para 6. The petition respondent begs to say that the plain reading of averment made in the interrogatory application is reproduced here in above. It became apparent that in the entire interrogatory application there is no averment to the effect that the present counsel of the applicant did not inform the applicant about the disposal of the repair store sought to be restored. The restored because submit that further from the plain reading of averment, it became apparent the applicant lacked bona fide in much as one the averment made in paragraph 11 of the interrogatory application. The previously engaged counsel did not inform them about the non-appearance. While on the other in paragraph 8 was said it is about that previous set of counsel failed to give satisfactory solution for restoration writ petition. So this is a contrary statement.
All right.
My lord, I have stated, my lord.
Yes. I am allowing it. I'll deal with both the averments.
Yes.
Heard Mr. G. Uddin.
Yes,
Learned counsel for the. It's already It's already 1 o'clock, so I'll come back and give this order.
No, one thing I'm just even if it is allowed, my lord, there is nothing in the writ petition because already
that
finished.
That is a different thing.
Because
at
already
the end of the day, it is the discretion of the court. The court has seen the averments. Court has also seen the objections. Your main objection is that there are some contradictory statements, but if you compare the 3 paragraphs, perhaps what they meant is that after they contacted the engaged, after they came to know, and because the earlier counsel has been defaulting after obtaining interim order, and thereafter the new counsel, you have to understand the entire. You can't just pick up one paragraph and say. Anyway, this court doesn't think that this is a case where.
No, my lord, even if it is allowed, my lord, it is a wastage of time because why I am telling you.
We are not going into that.
Yes, because the entire writ petition has already.
367. Whose name shall I record for the
And for the appellant.
No, but whose name should I record? You were not there in the first half. Heard Mr. Ahad?
G. Uddin.
Mr. G. Uddin, learned counsel for the applicants. Stop. Also heard Mr. S. Mitra, learned standing counsel GAIL, GAIL, appearing for the respondent number 4 and 5. Stop. MSS Borwa, learned government advocate for the state respondent. Stop. This interlocutory application has been filed by the appellants for condoning the delay of 357 days in the filing of the restoration petition for restoration of WPC number 1138 of 2021, which was dismissed for non-prosecution on 3/1/2023. Heard the parties and perused the averments made in support of the condonation application. Stop. The ground of delay is specifically averred in paragraph 6, 7, 8, 9 and 10 of the interlocutory application. The said paragraphs are reproduced hereunder for ready reference. Further, the respondents have also filed an objection praying that the delay ought not to be condoned and the writ petition ought not be restored. Stop. Paragraph 6. Paragraph 6 of the said objection filed on 24/5/2024 is also reproduced hereunder for ready reference. It apni page 30 pabora. Page 30. Aru yar agor paragraph kita je dilu eta apni page 6. Next. Perusal of the aforesaid averments made in the interlocutory application for condonation appears that the petitioner was unaware of the dismissal till December 2022 and that the advocate clerk with whom the petitioner was in contact died on 7/8/2022 and that thereafter arranging the legal expenses engaged new counsels who after taking some days filed the connected restoration petition which was in which a delay has occasioned. Stop. On the other hand, it appears the primary objection of the respondent is that there is contradictory in the version of the in the version of the applicant as regards the averments made in support for the grounds of condonation. Stop. Be that as it may, condonation being a matter of discretion of the court, unless and until the grounds averred is not sufficient or not bona fide, this court shall not destroy the rights of a party. Stop. Paragraph 8, 9, 10, 11, 12 and 13 of the decision of the Apex Court in the case of N. Balakrishnan versus M. Krishnamurthy, reported in 1998, volume 7 SSC at page 123, are reproduced hereunder for ready reference. Quote unquote. In this case, the explanation for the delay set up by the applicant is found satisfactory and sufficient, and accordingly the delay of 300 delay is 300 how many days?
57.
300 357 days is condoned. Application stands allowed. Disposed of. Sorry. Yes.
The connected, they have filed another, for restoration also they have filed a petition. That will, I think this petition is not been disposed of because the restoration
It is not here.
Yes.
So let's get ready.
Yes, madam.
Should let the connected IA for restoration be registered and listed before the bench. Yes, Mr. Das.
My lord, this is an IA for correction of the cost title, my lord.
Cost title?
Cost title, my lord.
What happened? What mistake?
My lord, this one, the petition, at page 3 of the main petition, the lordship will find that it was filed through an attorney. Now the attorney
Page
3 of the writ petition, my lord.
Yes.
My lord, petitioner 1, 2 and 3, so and so down below, my lord, represented by registered attorney Sri so and so. Now the attorney has expired, my lord. So now this IA has been filed for correcting this cost title.
Vincent Stone has been...
Yes, he was the attorney, he has expired. Now this IA we have filed that we want to correct the cost title.
Alright. Anyone at the side? Are you appearing, Ms. Gayan?
I'm appearing, my lord.
Any objection?
No, my lord.
Heard Mr. A. Das, learned counsel for the applicant, and also heard Ms. A. Gayan,
Yes, my lord.
learned counsel for respondent number
1 and respondent number, my lord.
1 and 2.
Yes, my lord. 1 and 2.
1 and 2. Stop. This and S. Borua, Ms. S. Borua, learned government advocate for respondent number 4 and 5.
You can also do 3, no?
3, 4 and 5.
3.
3 revenue.
And N. Borderlow, standing counsel revenue for R3. This is an application for correction of the... But Mr. Das, the representative capacity can be corrected in this manner?
No, look, after this cost title is corrected, then an affidavit will be filed in the writ petition that this...
Why?
This matter is that matter which your lordship had heard it, and this matter is that matter which your lordship had heard it, and this thing came to your lordship's knowledge better.
No, what I am trying to say is this the way to do it. There's no doubt it needs to be amended, but you will have to file an application because you see, correction of cost title is what? If there is something wrong, correct?
Yes.
Now here this is not a question of there being some wrong.
The wrong now here, my lord, it was represented by.
Correct.
This
In the meantime, this person died.
So now this represented by attorney's death has to be deleted from this cost title.
So deleted and then it has to be replaced by someone else.
So the petitioners are already there, my lord. Now these petitioners, they will file the wakalat.
Mr. Das, I have serious doubt about the manner in which this IA has been filed.
Yes, my lord.
Please please think over it. I'm just I'm listing it or I can list it tomorrow also, because what I'm trying to tell you is, at the end of the day, you want to remove this representative capacity, correct?
Yes,
and then you want the petitioners to be represented on their own. Now for that also here, I think something more has to be done, because this is a simple correction of the cost title. In what situation do you generally correct the cost title? When there is an impediment, when there is a struck off. Now these are done by the orders of the court.
Yes.
But where is the order of the court based on which this correction has to be done? So first an order has to come, then only the question of correction will come. For correction, you don't even need an application once you get an order. Then you may just submit the corrected cost title to the registry. Registry will do it. But you have to first come up with the application, with the proper application, not simply for correction, correct?
Yes,
so think over it, because what I've understood is that the representative part need to be changed now, in view of the fact that that this attorney holder no longer is alive.
Now the petitioners are already on.
Already there, and they wish to.
Yes, they will represent
so
themselves.
for that, there has to be an affidavit by them.
Because once this is corrected, then in the main petition.
No, Mr. Das, I think.
And this affidavit has been filed by this petitioners only. This in
You think about it. When do you want it?
Let it come after vacation.
List as prayed for, list this matter after vacation, or a date to be fixed by the registry of the ensuing vacation. Let registry reflect the name of SC revenue and register management in the cause list. All right. Hmm? 45. Yes, what is this?
This IA is for amendment of the petition.
First time?
First time. And I think they have no objection to
What is the amendment that you are seeking?
There was an order of this Honorable Court. The case relates to the enforcement of the civil administration in regard to a religious denomination. And that petition was filed against the interference by the civil administration regarding the administration of the religious denomination. And subsequently, order was passed by this Honorable Court. Your Lordship will find at page 41, Annex 1. And now part of the order at page 49, the District Commissioner Nalbari took initiative to hold the election of the denomination, and accordingly this Honorable Court has passed order. Last portion of the page 49.
However,
it is, however, provided that the District Commissioner Nalbari would ensure that the election of the Managing Committee, as notified on 19/9/2023, be held as per schedule and in a free and fair manner by adhering to the provisions of the Constitution of Sri Sri Hari Mandir, and the results thereof be declared as per the schedule. However, the results of the AGM election would be subject to further orders that may be passed in these writ petitions. So, there are laws of violation of the constitution of the denomination in regard to holding the election, and so the committee, newly elected body that has been sought for amendment to be incorporated them as a respondent here, and the subsequent events that taken place all These have been sought my lord, for incorporation in the for this amendment. This is the amendment. And relief portion also we have sought to amend regarding declaration of the present body as illegal and
These were not in your knowledge prior to filing the writ petition.
After filing of the writ petition, these are
These developments happen.
subsequent.
Yes, Mr. Nath.
As regards the amendment, I have no objection. Otherwise, my lord, on merits, my lord, we have already filed the affidavit in the matter. If the amendment is allowed, my lord, they will provide us the amended copy, my lord.
Obviously, that is the procedure. Right now, what is before this court is the amendment.
Yes, sir.
We will file consolidated application.
Which is paragraph 8. These are the amendments that you are seeking. Mr. Datta, are you appearing
Yes,
in this matter?
from the executive members. From paragraph 8.
All right, I am allowing the amendment. Rakhi and the IA, 1976 of 2024. Heard Mr. D. Chaudhary, learned counsel for the applicant. Stop. Also heard Mr. D. Nath, learned senior government advocate.
For respondent number 1 and 2.
Senior government advocate, Assam, for respondent number
1 and 2.
1 and 2, and Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, learned counsel for respondent number
10, 12 to 19.
10, 12,
12 to 19.
10 and 12 to 19.
21 to 23.
21 to 23.
27 and 20.
27 and
28.
28. And MS R. Barwa, learned counsel for respondent number 7, 8, 11, 20 and 30. This is an application for amendment of the writ petition being WPC number 5013 of 2021. It is the specific case of the applicant that after hearing the parties concerned, just one second. It is a specific case of the applicant that after filing the instant writ petition, certain developments have occurred for which the amendment sought has been necessitated. Stop. Mr. Nath, Mr. D. Nath and Mr. S. Datta, learned senior counsel, and MS R. Borwa, learned counsel for the respondents, submit that they have received no instructions to object the amendment sought for. Stop. But the parties peruse the materials available on record. Paragraph 8 of the IA is reproduced hereunder for ready reference.
Paragraph 9, 10 also.
9, 10 also?
Yes, 9, 10, 11.
Paragraph 9 starts in which page? There are long paragraphs.
Paragraph 8.
Paragraph 8 लिखिए. Paragraph 9, paragraph 10 and
11.
11.
9 is also there.
Yes, as I've said. 8, 9, 10, 11. Correct?
11 and 12 also, my lord.
And 12. Is reproduced,
And
are reproduced here under for
there is
reading.
pair portion also, my lord. That is at paragraph 13.
13 did you go? এবার আরম্ভ হয়েছে একেবারে পেজ 17 or pra 35. Huh? Are reproduced here under for reading. It appears that also 14.
My lord, paragraph 14 and 15 also, my lord.
14 and 15. A perusal of the aforesaid averments indicates that the same is required to be brought into record for effective adjudication of the writ petition. Stop. Accordingly, the amendment sought for is allowed. Let an amended petition, let the amended writ petition be furnished to the registry within
immediately after vacation.
within a period of 3 weeks from today. Stop. Disposed of.
During the amendment application, I had filed application for amendment that was filed in the City Montessori case, where the CAT building is in question.
Okay.
My lord, the Lordship was making a query as to whether.
But what is listed today? Only some writ petition appears to be.
No, my lord, the
Barpeta Jilla.
48.
Sorry, we have the next matter.
This is item 40.
My lordship.
That City Montessori school matter is also on board.
Yes.
Which is that? 46 and 47. Only 46. But that matter, I think, will take some time, right, Mr. Chaudhary? That's a part-heard matter.
I'll take about 15 minutes.
What is this matter, Mr. Sorania?
Mr. What matter relates to the my lord, this social
Regarding
certificate.
Certificates.
Of
In
the
the last occasion,
private
I have-
We can have it after the vacation.
Yes, Lordship.
Well, in the meantime, my lord, whatever record, my lord, if they are
Lordship, I have produced the records last occasion, but
That
my
is-
learned friend refused to accept this since it's a Xerox one. I have already produced the scan copy. Means it's a scan copy which we have received from the Directorate of
I
Tribal
have
Affairs.
recorded this submission.
Yes, Lordship.
All right. Due to paucity of time, this hearing could not be completed. List again on such and such date.
Lordship.
Give a date.
Any date, my lord, immediately after vacation.
Yes, 41.
41 may be taken up after vacation, my lord. I am for the respondent number 3 and 4.
You are for the petitioner. As prayed for, list this matter. Any date?
After vacation,
After 2 weeks on a date to be fixed by the registry.
or a date may be fixed, my lord.
That's why I'm asking on such and such date.
22 July. Yes, 26. Much.
Yes. There is another part-heard matter. 47. Which is this matter?
No, I think 46 is our matter.
No, I'll come to your matter. But 47 is a part-heard matter.
Yes, Your Lordship.
Then we'll have this after the vacation. There will not be time for this. Because we are rising early today. There is some
today there is a
reference.
Lordship, tally may be fixed immediately after the
Yes,
vacation.
sir. First Tuesday or Thursday did you?
Oblige.
Okay? Lucky?
Hello,
Due to paucity
before
of
my
time, we will go.
learned friend starts.
Yes.
The other day, Lordships wanted to know what is the scope of this amendment.
Legal consequence.
Yes. My Lord, Order 6, Rule 17 CPC, otherwise the law is very liberal in the sense, even before a judgment is delivered, amendment prayer can be allowed. But question is, if it alters the basic character of the proceedings, then there is an absolute bar. Now, what has happened in this case, my Lord?
Mr. Chaudhary, that is one part. Sorry,
Yeah.
I'm
No, it's okay.
At the outset, congratulations.
Thank you, thank you.
See, before even we go to the issue of amendment, the first thing that this is bothering with
What
this
is
court,
whether the live issue is
correct. Otherwise, to be very honest, I feel this matter has become infractious.
Yes.
Well, I will say there is a live issue.
That is the first thing, because
Yes.
unless and until this court finds that yes, the issue is live, then the question of going into the IA for an amendment will come. Because since the person who is representing the committee is no longer there after the election, there was an election or what?
No, there was not an election. General meeting was there.
After the general
In
meeting.
the general meeting, they were replaced. Somebody else.
There was a coup, my lord, I would say.
There was
a coup. It's a coup, my lord. It's not a general meeting, my lord. It's a kind of a coup.
Then my learned friend should establish how he became. He also that means came by a coup.
I'll come to that, my lord. I'll come to that.
I am not very, Mr. Datta, you please be very brief.
No, I'll be brief.
Please,
I'll be very brief, my lord. I'll be very brief, my
You
lord.
see, I am not going into disputed question of facts
Yes,
at this
Lord,
moment.
you will not go.
I will not. I have simply.
I'll just
see,
place
Mr.
this fact.
Datta,
I'll
on
place
the last occasion also,
My lord.
I had made my mind very clear.
My lord.
You show me that this matter still survives.
My
The
lord,
issue
I'll
still
show.
survives.
I will show, my lord.
That is the only thing.
The first thing that Lordship will consider, my lord, who can withdraw the suit, my lord? Who can compromise the suit?
I am not on that.
My lord, unless that is the question, my lord.
I am not on
because
that.
if that question is not decided,
See,
my lord.
There is one decision of the Apex Court
My lord.
in a similar situation.
My lord.
Sorry, not Apex Court, of the Meghalaya High Court, wherein there has been some change in the committee.
My lord.
This is also relating to a school managing committee.
My lord.
So there was some change.
My
Okay.
lord.
So a submission was made. So and so has also submitted that in any view of the matter, this petition has become infructuous inasmuch as the term of the SMC has since expired,
My lord.
and fresh process has to be initiated for constituting of a new SMC.
My lord.
It is prayed that this matter may be disposed of accordingly. And the end it says, in view of the above, this court is of the considered opinion that nothing survives in this petition as the same has become infructuous. Now, in your case, not only here, of course, the term was over.
Exactly.
Right, but in your case, a new committee has come, new members have come.
That is the precise question, my
Now,
lord.
I am not on, they are not saying
Well,
that withdraw, because they cannot come and say that we will withdraw. They are not the petitioner as of now, right?
My lord.
They got themselves implemented, that's a different thing.
So, my lord.
But the question is not about withdrawal. The question is, can you still represent that committee and challenge those orders where the new members representing the committee has taken over the land?
Exactly, my lord. Can they compromise the suit? That is the question, man.
All right. Let me hear you.
My lord. Can they compromise the suit, my lord? The subject matter, my lord. Lordship, my lord, there is a specific bar.
All right.
There is a specific bar under CPC, my lord. And my lord, I'll just place the facts a little more, my lord. The committee, my lord, before they implemented this suit, my lord, they have taken over possession of the land, which was meant for us, which we refused to take, my lord. Now, Lordship will find, my lord.
Mr. Datta, you are again going to facts. You see, even on the last
No, my lord,
occasion,
without the facts, my lord, how can I place, my lord, the
legal position.
Yes, my lord, the facts have to be
The
based on
fact-
legal position, my lord.
you see,
my lord, legal positions are based on facts.
those
my
are
lord.
disputed questions.
No, my lord.
You are
No, I'll come to that.
disputing the
Exactly.
constitution of that committee.
Exactly, I'll
This
come to
court
that.
is
I'll come to
conscious
that.
of that fact.
I'll come to that, my lord. Come to that, my lord. Let me address this on that issue, my lord. Lordship will see, my lord. Order 23, my lord.
Order 23?
On CPC, my lord.
Yes.
Now, what they're trying to say, my lord, is that we have, my lord, buried our hatchet. We have buried our differences with the CAT authorities, and we
Forget that. Forget that.
because that is what has happened. Ultimate
All right.
result.
So
Ultimate. That is
first,
the ultimate
show me
result,
the
my lord.
provision 23.
My lord.
You may be correct, Mr. Datta, but enlighten me.
My lord,
23.
withdrawal and adjustment of suits, ma'am.
One second. Yes, 23. Order 23 rule.
I'll start from 1 minute.
Yes, please start.
At any time, after the institution of the suit, the plaintiff may, as against all or any of the defendants, abandon his suit or abandon his part of the claim. So what I can do, my lord, I can only abandon my claim.
And who is this? The school authorities? There it is a committee. Is a registered.
It was not a registered committee, my lord. It's a representative capacity, my lord. The suit has been filed, my lord. The committee.
It's a corporation.
No, my lord. Basically it's an unregistered association, my lord. Okay. The school also represented by the secretary, and the secretary personally, my lord, is a party, my lord. Now, my lord, provided, my lord, there's a minor that is not we are affected, my lord. Then, my lord, 1A, my lord. First part is then the second, my lord, provision is with regard to minors, my lord. We are not concerned, my lord.
Then 2.
Then, my lord, 2, my lord, 1A, my lord.
1A.
A, my lord. No, my lord, sorry, my lord. 4, my lord, 1, my lord.
Where the plaintiff abandons.
Well, 1, my lord, 4 will be
yes, where the
plaintiff abandons or any part of the suit or claim under sub-rule 1 or withdraws from a suit or part of the claim without the permission referred in sub-rule 3. He shall be liable for such costs as the court may award and shall be precluded from instituting fresh suit in respect of such subject matter or part of such claim. Nothing in this rule shall apply to be deemed authorities of the court to permit one of the several plaintiffs to abandon a suit or part of the claim under sub-rule 1 or withdraw sub-rule 3 or any part of the suit or claim without the consent of the other plaintiffs. Even, my lord, with regard to co-plaintiffs, my lord, there is a restriction, my lord. It cannot be done without the consent of other plaintiffs, my lord. When transposition of defendants as plaintiff may be permitted. When the suit is withdrawn or abandoned by the plaintiff, we have not abandoned, my lord. Under Rule 1, and the defendant applies to be transposed as a plaintiff under Rule 10 of Order 1.
Defendant applies.
It applies as to be transposed as a plaintiff under Rule 10 of Order 1. The court shall, in considering such application, have due regard to the question whether the applicant has a substantial question to be decided as against any of the other defendants. Limitation law not affected by first suit, that is of course not relevant to us. Then 3, compromise of suit. Where it is proved the satisfaction of the court that the suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, and where the defendant satisfy the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise or satisfaction to be recorded and shall pass a decree in accordance therewith. So far it relates to the parties to the suit, whether or not the subject matter of the agreement, compromise or satisfaction is the same as the subject matter of the suit. Provided where it is alleged that one of the party, alleged by one party and denied by the other, that the adjustment or satisfaction that has been arrived at, the court shall decide the question, but no adjournment shall be granted for the purpose of deciding the question, unless the court, for reasons to be recorded, thinks it fit to grant such adjournment. An agreement or compromise which is void or voidable under the Indian Contract Act shall not be deemed to be lawful in the meaning of this rule. Then bar to the suits will not there, my lord. Then 3B. An agreement, no agreement or compromise to be entered in the representative suit without leave of the court. No agreement or compromise in a representative suit shall be entered without the leave of the court, expressly recorded in the proceeding, and such agreement or compromise entered into without the leave of the court so recorded shall be void. So therefore, my lord, what they are claiming is that we have come to an agreement with the other sides, and my lord, they have decided to abandon the claim, my lord. There is no agreement with me as such, my lord. They are only saying, my lord, that we have come as a new committee, my lord, and therefore, my lord, they sought implement as a defendant, my lord. They have not asked to be transposed as plaintiff, my lord, or the petitioner here. They have, my lord, only come as a defendant. Now the question, my lord, therefore would be, my lord, even if they have agreed to, my lord, do something, give away something, my lord, to the other respondents, my lord, can they do it without, my lord, without an agreement with me, my lord? That's the basic issue. Therefore, my lord, my amendment of the pleading is necessary in the sense that, that's what I'm coming, these are related questions, my lord. It is necessary because, my lord, once they've implemented in the suit, my lord, I must have my material pleadings there, my lord. Without the pleadings, will I be prejudiced, my lord. Therefore, my lord, in this case, my lord, what they're claiming is that they have come in my place. That has also to be established. And it is not as if, my lord, I am trying to bring in a new cause of action. I am not, my lord. Once they're impleted, my lord, I have the right to, my lord, bring in my pleadings, my lord. Therefore, in my humble submission, my lord, it is not a case, my lord, where it can be decided, because that was a case your lordship is referring. That was the expiry of the term of the SMC. The new SMC had to come in. That's a totally different issue. Here, two committees are saying that we are the genuine committee. Well, we filed the case. When we filed the case, they're not saying that at that point of time we are not the committee member. They're not disputing that. They say in subsequent point of time we came in and we have decided to undo things which were done by the other committee. Now, in that circumstance, my lord, that's my prayer, my lord. That is the reason, my lord, I'm my lord, pressing hard for this, my lord. Otherwise, I wouldn't have, my lord. Therefore, my lord, their case that they have compromised this, my lord, how can they do it without me, my lord? And as the lordship has seen, my lord, they have already entered into an agreement, my lord, by signing that letter, my lord, by accepting the land, my lord. That is void, my lord, ab initio. They couldn't have done without taking permission from your court. First, they ought to have applied for leave of this, my lord, to be implemented, my lord, or thereafter perhaps transposition, my lord. And then thereafter, they would have signed the agreement and taken the land, my lord, which belongs to the school, my lord. My lord, if this is allowed, my lord, unscrupulous people, my lord, will be allowed to grab the land, my lord. It's another different story, my lord. Therefore, my lord, my humble submission is, my lord, when the issue here is, my lord, the land which was provided to us, my lord, that is not sufficient to school for
provided a school. To us means?
My lord, what happened? Our land was taken and given to the camp.
Us and our means what? Is,
my lord,
is the land been given to petitioner number 2?
School. So which was given to the school initially, well, that was 2 bigha, my lord. Now, after this transfer, my lord, our land was sought to be given to the cat.
Petitioner number 1.
Petitioner's land. And the land of the cat was sought to be given to the school. Now, as per the requirement of law, my lord, 2 bigha land is required for the school, my lord. 4 kata of land is not even sufficient for the school, my lord, under the Act, my lord, Education Act.
Now, the prayers that you are seeking at page 24.
Those are factual issues I'll address, my lord, because there are a lot of issues to be decided, my lord. What has happened, my lord, it is supposed to be based on a cabinet decision. But I'll show from the records, my lord, before the cabinet decision took place, the land was handed over to CAT, my lord. How could it have been done, my lord?
All right, come to the prayer portion.
Which, my lord? The repetition?
Yes,
my lord.
See, on merit, I am not saying that prima facie looks like there are
exactly,
yes, but right now I am on a very different. Just come to the prayer portion once. Prayer portion.
Prayer portion, yes, ma'am. Page 24, ma'am. Page 24.
Yes.
Yes, ma'am. Read in the nature of such setting aside the letter dated.
Which is this letter 11/22?
Annexure 20.
No, what is this letter by which?
My lord, circle. This is a letter by the circle official, my lord.
By which? What happened?
By this letter, my lord. Just place it, my lord.
No, I don't want to go to the letter. Please tell me what happened by this letter, 11/3/21.
By this letter, my lord, the land has been handed over to CAT, my lord, our land of the school, my lord.
P1's land. Let us be more clear.
Pardon, my lord?
P1's land, because the land cannot be yours. Cannot be of P2. P1's land.
P1's land.
Handed over to CAT.
Handed over to CAT, my lord. Now, this is dated 11/3/2022, my lord. And the cabinet decision, my lord, came on, my lord.
And the next prayer?
Next, my lord, is the, my lord, order of the Deputy Commissioner dated 8/3/2000, my lord, 2022, my lord.
What is this?
This is, my lord, your letter. My lord, I'll just get the number, my lord. Just a minute. A322, my lord, is the letter by the circle officer to hand over the land to the tribunal.
Hand over the land to?
The tribunal, my lord. That is annexure Q of
This is handing over.
Handing over, my lord.
Handing over to CAT.
CAT, my lord. That is annexure Q.
And then 3?
My lord, 3, my lord, is the proposal of the subdivision level committee, my lord, which my learned senior friend they read out, my lord. That is, my lord, page 80, my lord.
This is in favor of CAT.
This is also in favor of CAT, my lord. Here some false reporting has been made, my lord.
Then cabinet decision
then, my lord, the
to allot the land.
That we do not have, my lord, but it was since we were informed with the court.
All right, it is part of your part of the reliefs.
Yes, my lord.
Then 13/4.
My lord, order dated, my lord, 13/4/2022, my lord, pursuant to the cabinet decision, my lord. That is, my lord, 13/4. There is an annexure U, my lord. By this, by this order, my lord, the Revenue Department orders land of the petitioner be given to CAT and vice versa, my lord.
To given to CAT.
CAT and vice versa.
Basically, all these 1 to 5 are relatable to the land in question to be given to them, given to the CAT, use of the tribunal.
P1 to CAT.
Correct. And then next 6, DC's order 8.3.
My lord,
this is that same order, handing over to CAT.
8 over same, my lord. That's
Correct.
a repetition.
Handing over CAT.
Yes, ma'am, that's a repetition. Sorry, ma'am, this is a repetition, my lord.
To allot the
land to the
land. Not to allot the land allotted to the petitioner to any other person.
Person, institution handed over back, my lord. And handed over back to us.
Now, in view of the development that the school committee, this is a committee, school managing committee?
They say new managing committee, yes.
No, I'm not saying they. When you filed it also, you are saying it's a school managing committee?
Yes.
Why are you in the defensive all the time, Mr. Datta?
No, I'm not a defensive.
So this is a school managing committee.
Yes.
Now this school managing committee, in the meantime, there has been the development is that a new set of person is claiming themselves to be the elected members of this committee through a general meeting. And has got themselves implemented. This is the development that has happened.
This is development.
For your benefit, I am saying claiming this time.
Yes.
And because of that development, you have come up with an amendment application wherein now you want to bring those facts whereby you are challenging the composition and constitution of this new committee, correct?
I am not challenging the composition.
Then what is that you are bringing in? Because one of your relief is also not to recognize that committee.
No, that is not relief. The relief I am claiming, the additional relief that I am claiming, that letter by which
they have taken over.
That is to be set aside. I have not changed the composition here. But with regard to the composition, my lord, I have my pleading because since they have been implemented.
So according to you, this new committee, which you do not accept,
my lord,
has come into existence in an illegal manner and now have settled the matter with the government by handing over.
Exactly.
Which otherwise has the effect of abandoning your claims raised in this writ petition. This is what you are saying.
Exactly.
And what are the what is the amendment that you are seeking there? What paragraphs?
I have to bring certain pleadings.
Which pleadings?
Pleadings, my lord.
Just give me in brief.
Yes, well, with regard to the composition of the committee, that is a fake committee, my lord. We lodged a complaint before the police. We had a paper notification published that you don't deal with this committee.
When I said that you want to bring this, you said no. The composition, this is the fact that you want to bring in, right?
No, but that's not I have not challenged the composition. What I'm saying, that committee, the way they have been formed, my lord, it doesn't constitute, it is not a proper committee.
But Mr. Datta, unless you challenge that composition, how can the court go into that? Because in paper, now there are documents showing that they have been...
No, I understand, the composition, of course, I have to, that's a
you have to, unless you see, Mr. Datta, the biggest hurdle that is coming on your way right now is because of wrongly constitution of this new committee. And because if you read the reliefs which we read together, it appears that all this relief is for the school, not for your individual.
No,
correct?
Right.
The land is given to the school. Rightly, wrongly, a new committee says they have come. Now, if that constitution you do not challenge in that manner, this writ petition, in the opinion of this court, becomes infructuous. Because you are not challenging. You cannot simply make a government saying that they have wrongly been brought and all that. But otherwise...
Well, my also prayer has been, my lord, that it should not be allotted to someone else, my lord. No other person, my lord. No other person or institution and hand it over back to us, my lord. That was the initial prayer.
To us, it will be to the school, not to you in person.
Of course, the school, my lord. I am not seeing as a representative.
And right now...
I am not claiming it on my own.
Anyway, you finish your argument.
So therefore, my submission will be, my lord, since, my lord, the committee, challenging of the committee will be perhaps a separate proceeding altogether. Here the issue is, lordship will have to decide, my lord, whether, my lord, they can, my lord, really abandon the claim on my behalf. If they can, my lord, under the circumstances, my lord, perhaps, my lord, I don't have any case. But, my lord, even without the constitutional challenge of the committee, my lord, whether there's a defendant, my lord, can, my lord, have a compromise with the other defendants, and my lord, abandon the claim, my lord, which was filed with the other committee, my lord. Now that issue, my lord, because here that issue is very vital, my lord. Unless, my lord, then what happens, my lord? How the entire proceeding that has taken place, my lord? Since they say that if they say we have compromised, my lord, then things are different, my lord. Since we are saying they have not compromised, my lord, the lordship has decided the entire issue. Now, if a lordship finds that the writ petition is not maintainable and the rand was lightly given to the cat, perhaps things will be a little different.
No,
but,
I am not getting into
I'm just, my lord, saying, my lord, ultimately, my lord. But, my lord, at this moment, since they have been implemented, my lord, they have got themselves implemented, my lord. It's not that I prayed for the implement. Since they have got themselves implemented, my lord, some pleadings, my lord, that may be sufficient, insufficient, that's a separate issue which your lordship will decide in the final hearing. But at this moment, my prayer would be, my lord, let the amendments be, my lord, allowed to be made, because this pleading is a vital, my lord. This pleadings, my lord, lordship will thereafter consider whether these pleadings are sufficient or that's a separate aspect of the matter, my lord. Amendments, my lord, are to be considered liberally, my lord. That's a law, my lord, has been laid down. I have a judgment of 2023, my lord. And, my lord, it should, where their material particulars are missing in the plain, my lord, then, my lord, it has to be brought in, my lord. That is the amendment, my lord. Even where material particulars in the plain, because I don't have any material particulars against this newly implemented respondents, I have to bring those particulars against them, my lord. So unless those are brought on record, my lord, how can I make even an argument on that, my lord? Whether, my lord, therefore, this issue is very relevant. Anybody, but this, otherwise, lordship will say this is a very dangerous trend. Anybody's land can be taken away by anybody saying that I am the new owner. That cannot happen, man. That's a very dangerous situation, man. That will lead to chaos altogether.
Which is that document by which they are showing that they have come in?
Well, they have filed, my lord, in the implementation petition, in the affidavit in opposition, or they have brought on record, my lord. They have taken a resolution, my lord. They have taken rather a resolution, which I have, my lord, in my amendment application, I have put it there, my lord. I have filed an RTI application and got those documents, my lord.
Yes.
Now, my lord, Annexure A1 at page 20 is my paper notification, my lord, publication, saying that this committee is in, my lord, paid committee. Then, my lord, I have got through RTI, my lord, that they have registered themselves.
3:30 hour aage Yes.
Yes, my lord. Annexure A2 is the registration certificate which they
page, sorry, Mr.
Page 23, my lord.
Affidavit of R5?
My lord, no, my lord. I am relying upon my amendment application.
Amendment application?
Yes, my lord. I have brought those on record.
Ekhon amendment application ekhon ase na ekhon dia na. IA number?
IA number, my lord, 1959, public 24.
Yes.
Page 23, my lord, is the registration, my lord, the registration certificate, my lord, and the farms and societies.
Page 23?
23, my lord. Then, my lord.
One second.
My lord. Sorry, this is my RTI application. Sorry. 24 is the certificate.
24. Registration society. Yes.
This is to hereby certify that City Mandasari High School Porisalona Committee, Birubari, RK Mission Road, so and so, has been registered under Societies Act 1860. Then, my lord.
This is the old one?
No, that is the committee they are claiming to have formed.
This is the one?
Yes, yes.
City Montessori High School Porisalona Committee.
It is, my lord, it is, in fact, my lord, it's, yes, my lord, it was issued on, my lord, 29, 2022.
29?
2020.
Where do I find the date?
Bottom, my lord, bottom. Page 24, my lord.
Yes.
Yes, besides the QR code. Yes. Then, my lord, it's valid up to 2025, my lord. Lordship will find it at the top.
This is the certificate of registration of societies act.
Yes, sir.
So, and the earlier one?
No, earlier was on my RTI application, right?
No, your entity was what?
Oh, well, my entity is unregistered. I was unregistered. Not very unregistered.
It was unregistered.
It was unregistered. That is not disputed. Then Lordship will see, my lord, annual general meeting. Page 27 is a typed copy. My lord, this is in the letterhead of some people, my lord. This is the annual general meeting of a school committee, my lord, 1/8/2022.
Yes.
10 persons, my lord. 10 persons grouped together, and my lord, they hold an annual general meeting of the school committee, my lord.
So you have not challenged this, Mr.
No,
Datta.
I understand. I'm coming to that.
And how many persons your committee comprises?
One
person.
Anyway,
that
all right.
Malad.
Yes, Mr. Datta.
Then, Malad, this is a resolution, Malad.
That we are lawyers.
Then it's a resolution, Malad, taken by Malad, some people, Malad.
Resolution at page?
Page, Malad,
29.
29.
Yes.
Yes. General meeting under the held the presidency of Dilip Das, so and so. Then, my lord, the name of the society is given by the meeting SCT Montessori High School Porisalona Committee. Then, my lord, 9 members, my lord, the committee has formed, my lord. And, my lord, I have also made an allegation that most of these persons are fictitious persons. They are not even available, my lord, to be found, my lord. Many of these committee members, my lord.
Yes.
Then, my lord, Lordship will see, my lord, this meeting was held somewhere in place of some residence, my lord, of some person, 41.
On 1/8.
Page 41, my lord.
Page 41.
Yes, my lord. In the residence of one Dhoniram Das.
Who is he?
We do not know, my lord.
41 is an affidavit.
Yes, my lord. That affidavit shows, my lord, with regard to the meeting, my lord.
Acha.
Well, sorry, it's regarding the a room being rented out to this society. They hold this meeting there, I guess. Sri Rajendra Das, resident of Birubari, so and so. I am a citizen of India, so and so. And the owner of plot of land, so and so.
What is this affidavit? What is this affidavit?
This is an affidavit by which they hold a meeting in some place, my lord.
Affidavit for holding meeting?
Yes.
What affidavit is required for holding meeting?
But taking a place on rent for holding a meeting, madam. That's their office, supposed to be office or something like that.
Who is Dinaram Das?
We do not know, madam. Who are they?
No, he says, I am the owner or possessor of Assam Type House.
But he is not a part of the committee, madam. He is not a part of the committee.
That have lent.
He has given his house on rent for the Porisalona committee to function. Then, my lord, we lodge an FIR before the Commissioner of Police. We lodge an FIR before the FIR as well. Since the FIR was not registered, my lord, we lodge a complaint with the Commissioner also. We lodge a complaint with the Commissioner for, my lord, registering the FIR.
All that is all right.
Nothing has been done thereafter, my lord. And, my lord, the land, they have taken over the land, my lord. Lordship will see how the land has been handed over, my lord. In presence of the resolution of the Deputy Divisional Office, Subdivision Land Officer Committee, in pursuance of the resolution of Subdivision Land Advisory Committee, meeting held on 19/5/2022 at 11 am in conference halls of the Deputy Commissioner Swenso, land measuring 4 Katha 10 Lecha, covered by Dag number so-and-so, has been allotted in favor of the principal City Montessori School for construction of school building, and accordingly the possession is the said land is taken over by the principal. Now, my lord, sign is not by the principal, my lord, it is by one Dilip Das, my lord. He is supposed to be the secretary, he is not the principal, my lord. And then Lordship will find, my lord, on such a date, my lord. And this date, my lord, Lordship will find 23/9/2022. Now, my lord, before entering into this land, before compromising the land, my lord, before getting into this land, my lord, where is the compromise agreement, my lord? Where is the leave of this court, my lord? This matter was pending before your lordship at that point of time. How could they have come in between, my lord, just like that, my lord, and grabbed the land, my lord? As I have shown, my lord, order 23, my lord, they ought to have taken permission from this lordship, my lord. They ought to have filed the implement petition earlier. So now we are the new committee, so we want to take over the land, please grant us the permission. Nothing has been done, my lord. So therefore, my lord, this is a case where, my lord, if this is allowed, my lord, it will lead to
anything more?
My lord.
Anything more?
My lord, that's my principal submission, my lord, is that since, my lord, this is related to the amendment application, my lord, once they've been implemented, my lord, I need to, my lord, get in the pleadings.
Don't
whether
repeat.
it is sufficient or that's another
understood.
issue, my lord.
All right.
Therefore, in my humble submission, your lordship will allow the amendment, my lord. Thereafter, hear the matter, my lord, and decide, my lord. That's my humble prayer.
All right. Yes,
Lord,
Mr.
kindly
Chaudhary.
take the. My lord, I'll just place one judgment of amendment. Should I place one? I'll place it.
Judgment of?
For amendment, my lord, on the amendment, my lord.
Yes. Mrs. Chaudhary, for which matter are you waiting?
My lord, the summaries are there, my lord.
She is waiting for this matter.
Yes.
Summaries, lordship, fine, my lord. The prayer for amendment is to be allowed when, my lord? Page, my lord, it is page, my lord, 25.
The photocopy is not very legible, Mr.
My lord,
Dutta.
the copy also, I also got, my lord, somewhat, my lord, some...
Para 25.
Para 25, my lord.
Yes.
The prayer for amendment is to be allowed if the amendment is required for effective and proper adjudication of the controversy between the parties, to avoid multiplicity of proceedings provided the amendment does not result in injustice to the other. By the amendment, the rights parties seeking amendment does not seek to withdraw any clear admission made the party which confers the right on the other side. The amendment doesn't raise a time-barred claim resulting in divesting of the other side of a valued accrued right. A prayer for amendment is generally required to be allowed unless by the amendment time-barred claim is sought to be introduced, in which case the fact that the claim will be time-barred becomes a relevant factor for consideration. The amendment changes the nature of the suit. Well, in my humble submission, my lord, once they are implemented, my lord, I have the right to get my amendment, my lord, pleadings, my lord, amended, my lord. It is not as if, my lord, I am trying to change the character of the suit, my lord. Then, my lord, by amendment, the other side loses a valid defense. In dealing with the prayer for amendment pleadings, the court should avoid a hyper-technical approach and is ordinarily required to be liberal, especially where the opposite party can be compensated by cost. Where the amendment would enable the court to pinpointedly consider the dispute and would aid in rendering a more satisfactory decision.
In short, you want to say if the amendments that you are seeking are effective, are necessary for an effective adjudication of the issue involved, then it should be allowed. Correct? This is what basically...
My lord. And my lord, then the amendment is maybe justified, maybe justifiably allowed, where it is intended to rectify the absence of material particulars on the plaint. Now we don't have any particulars against the respondent number 10 and 11 in the plaint, my lord, when the suit was filed, because that was not a development then. It is a subsequent development. So subsequent development, therefore there is a necessity of amendment. Since all these developments are subsequent, my lord, that's my prayer, my lord. Right. So therefore, my lord, this is an amendment, my lord, which is required to bring in, my lord.
Therefore, every case and every application for amendment has to be tested in the applicable facts and circumstances of the case. Correct? Part 26.
My lord. So therefore, my humble submission is that this has become necessary because of the, my lord, impediment, my lord, and therefore the amendment has to be allowed. That is my prayer.
Yes. My lord, will kindly take the writ petition for a moment.
Yes.
Please come to page number 6.
Page number 6, yes.
Yes. Para 1.
Yes.
That the petitioner number 1 is a school recognized by SEBA and all its members are citizens of India. Petitioner number 2 is also a citizen of India, and as such they are entitled to all right, protection, privilege, etc. Then please come to para 2. The petitioner school, number 1 school, City Montessori, was established in the year so and so, is represented by its secretary, the petitioner number 2. The petitioner number school is imparting education up to class 10 and efforts are on to extend the classes up to 12th standard. Other than these two paragraphs, there is nothing in the writ petition as to what is the status of the school. We all know, my lord, if a society is not registered, an unregistered association of person cannot maintain a writ petition. Number 1. Now please come to page 85, my lord. My learned friend has brought CPC, I am happy. Now he will have to answer his own CPC now.
85.
Please come to page number 88.
This is some title suit.
Yes.
Filed by this very petitioner.
Yes. Suit was withdrawn without liberty.
I will satisfy that.
For what?
I will satisfy that, madam. I will satisfy.
Mr. Datta.
Well, I will satisfy that, madam.
Oh, there is a reference today. So when can we have it? Tomorrow? I don't know if there will be time. Lot of motions. And the reopening?
I don't have any difficulty, madam. We also want this matter to be resolved early.
When do you want it, Mr. Chaudhary?
Except 17th, madam. 17th.
15.
15? Yes.
Or maybe on the 16th.
16 will be Tuesday.
16, well, 16.
And Lordship will treat it as part of
Rakhik Didiban, but hearing remain inconclusive. List again on so and so date. এইটো ভৰাই থৈ দিছোঁ নহ'লে থাকি যাব এই দুটা এই দুটা এই amendment application. All right. 16? Okay.